to call this meeting to order. Will the clerk please take roll call attendance?
Chairwoman Coyne.
Here.
Senator Raptakis.
Here.
Senator Burke.
Here.
Senator Oyer.
Here.
Senator Lombardi.
Here.
Senator Casada.
Here.
Senator Rogers.
Here.
Senator De La Cruz.
Here.
Leader McCaffrey.
Leader McCaffrey, you're muted.
Hello?
Yes, you're here. Thank you.
There are 9 members present. You have a quorum.
Thank you very much. For the public, we have 13 bills on the agenda for hearing this evening, and over 100 registered witnesses. It's going to be a very long night, and I'd like to take care of some housekeeping on tonight's agenda first. If I could have a motion to indefinitely postpone Senate Bill number 131 and bring forward to the committee Senate Bill number 131 sub A. May I have a motion?
So moved.
Senator Oyer, so moved.
Thank you. Thank you, Senator Oyer. Senator Raptakis, will you second that?
Second.
Yes.
Thank you. The motion made by Senator Oyer and second by Senator Raptakis. Mr. Clerk, will you please take a roll call on the vote?
Chairwoman Coyne.
Yes.
Senator Raptakis.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Casada.
Yes.
Senator Rogers. Senator De La Cruz.
Yes.
Leader McCaffrey.
Yes.
There are 9 in the positive and none in the negative.
Okay, and the vote was unanimous. In keeping with existing virtual protocol for this committee, I would ask for a motion to hold all 13 of these bills before us for further study. May I have a motion, please?
Senator Oyer moves.
Thank
Second.
you. And seconded by, was that Senator Lombardi?
Senator Lombardi.
Thank you, Senator. Mr. Clerk, will you please take a roll call?
Chairwoman Coyne.
Yes.
Senator Raptakis.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Casada.
Yes.
Senator Rogers.
Yes.
Senator De La Cruz.
Yes.
Leader McCaffrey.
Yes.
There are 9 in the affirmative and none in the negative.
And the vote was unanimous. Thank you very much, everybody. In an effort to utilize both the sponsors and the public's time more efficiently while conducting these hearings virtually, I will ask each of the sponsors, if they're present, to introduce and explain their bill. And then upon conclusion of the sponsor's introduction and explanation, after we get through all the 13 bills by sponsors, we will then take public testimony on each of the bill in the order of the agenda. So the first bill up for hearing this evening is Senate Bill number 443 by Lita McCaffrey, an act relating to health and safety, the Hospital Conversions Act. Welcome to the committee.
Thank you, Madam Chair and members of the committee. I'm pleased to introduce this bill, which would increase the accountability and transparency within the Hospital Conversion Act. As you're all well aware, Rhode Island's 2 largest healthcare networks, Care New England and Lifespan, have announced a tentative merger. It's believed it's in the best interest of Rhode Island to ensure a merger of this nature would be looked at relative to the jobs, community service, and most importantly, patient quality care. It's important that because it will impact every Rhode Islander, these 2 hospital networks have a varied array of practices within them. 2 hospital transfers have received over the last couple of years an expedited review. One is Memorial, the other is Westerly Hospital. Memorial Hospital is now closed, and Westerly went through a subsequent conversion, but has substantially reduced services there. I know that Care New England and Lifespan have said they don't want to go through the expedited process, but what this bill would do is exempt out any hospital emerges where the hospitals are going to consist of more than 20% of the hospital beds. And these two hospital networks do that. Second, the legislation looks at a number of different things within the Hospital Conversion Act to give the Department of Health and the Attorney General's office more ability to get additional information and have that information reviewed by the experts to analyze such things as staffing levels, potential relocation of services, and other aspects, both pre and post conversion. My first concern for services, of course, the staffing levels at Kent County Hospital. Kent is a community hospital located in the heart of Kent County and located in Warwick, and it's the hospital of first resort for many people in the area. Kent also has a number of valued employees at that hospital, and we want to make sure that when this conversion takes place, that these employees are taken care of, and they're not going to be outsourced, that we're not going to have a lot of services go overseas and things of that nature. This just gives the Attorney General and the Department of Health the ability to examine more information. It doesn't oppose the hospital conversion between Care New England but it allows more information to be provided to the parties. And thank you, Madam Chair. And if any members of the committee have any questions, I'll gladly try to answer them.
Thank you, Lita. Do any committee members have any questions of Leader McCaffrey at this time over his bill? Okay, I see none at this time. Thank you very much for joining us this evening, Lita.
Thank you.
The next bill will be S-131 Sub A, sponsored by Senator Bell, an act relating to property, residential, landlord, and tenant act. Senator Bell.
Thank you so much, Madam Chairwoman. And thank you to the committee for bringing forward the Sub A earlier during the hearing. This legislation came to me because a constituent of mine had quit her job as a CNA to move in with her mother, and at the end of her mother's life. And then her mother died, and she was immediately homeless, because currently under Rhode Island law, if the leaseholder of the unit, of the rental unit, dies, and there are no other remaining leaseholders living in the unit, then the contract is terminated. Anyone else living in the unit has no rights. What this bill would do is allow someone else who's living in the unit of at least 18 years of age a right to continue the contract, the lease agreement, for up to 3 months, not to exceed the end of the term of the lease. And the idea is to give people a grace period, time to go find a new apartment, so that they're not immediately homeless. And in my constituent's case, she had no time. There's no 30 days eviction process, none of that. She was just immediately homeless. And the idea here is to provide a grace period. This is similar to the version of this bill I've introduced previously. However, I've added a couple of other additional technical issues, such as the allocation of security deposits and clearing up some other ambiguities. And with that, I would be happy to take any questions.
Thank you, Senator Bell. Do any committee members have any questions of the senator at this time? Okay, I don't see any. Senator Bell, thank you so much for your testimony this evening.
Thank you so much.
You're welcome. Next on the agenda is Senate Bill 183 by Senator Oyer, an act relating to property, residential, landlord, and tenant act. Senator Oyer.
Thank you. This bill is really about trying to learn from our experience of COVID and address some pretty important issues as it relates to housing. And this creates both a eviction foreclosure moratorium during a state of emergency, as well as an eviction diversion mediation program during basically any time. The eviction and foreclosure moratorium during a state of emergency is really critical because, homelessness is bad any time of the year, and especially in a state of emergency. And families who are vulnerable to evictions due to, low income, are more likely to be impacted by states of emergencies. And that's exactly what we saw happen during COVID. People who were least able to afford to miss a paycheck were the first folks to be laid off from their jobs and therefore at risk of eviction for non-payment of rent. In Rhode Island, a lot of the protections and coverage that was allowed through the moratorium process really was reliant on the CDC moratorium, as well as work and effort by our courts in order to try to stem, quite frankly, an additional public crisis of homelessness on top of a pandemic. So this is really trying to codify into law the ability for us to have a state moratorium in times of emergency only. The other thing this does is it sets up an eviction diversion program using the tool of mediation. And it's been, mediation is a tool that is used around the country. And if Rhode Islanders have access to mediation before an eviction is filed, the vast majority of these cases will be able to reach a resolution before ever needing to go to court. That will save landlords money. That will save the tenants a lot of headache and heartache. It will allow the landlords to be made whole, because part of the reason for this bill and the impetus behind it is the fact that the stimulus bill that passed in December 2020, as well as the stimulus bill that just was signed by President Biden today, includes funds for rental assistance. Through the last year, we have received rental assistance funds from federal stimulus that has been managed through the Safe Harbor program. And so this basically would take the place of that. And, through those programs, it allows the money to go directly to the landlords and again, to make the tenants' obligations whole, make sure the money gets to the right place. And, again, allows for mediated settlement without court costs and without court aggravation. So that's really the intention behind this bill, is to, try to address a really complex public policy need. I know that there is a lot of discussion around this bill. I've seen a lot of emails circulating and a lot of questions. So I will tell the committee this is the first time that this bill has been introduced. I know that there are concerns. I look forward to working with folks to try to make sure that all of those concerns get addressed throughout this committee process, which, is what this legislative process is about. So I am happy to answer questions. I will say that I've been working closely with the Center for Justice on this legislation. I do believe we're going to be hearing from Jennifer Wood and Jordan Mickman this evening, and they both are probably better suited to answer questions that are more technical in nature, but I'm also happy to field any questions from the committee.
Thank you, Senator Oyer. Are there committee members who have questions of the Senator?
Madam Chair, may I be?
Yes, Senator Lombardi.
Thank you. And while I laud my colleague from Newport on the intent of this bill, one of the biggest concerns that were raised, not only did we get emails, we got phone calls inundated at our respective law offices, Senator Oyer, on this all afternoon. But one of the issues that was raised that's particularly poignant to me was that the Attorney General office, and I think concurs with Chief Judge LaFazia, that we may be usurping on a separation of powers issue with this bill and the right of the courts to conduct their own calendars. That's the biggest concern that I want to see resolved first and foremost before we get to anything else. And that's just by way of commentary. Thank you, Madam Chair.
Thank you, Senator Lombardi. Yes, Senator Rogers.
Thank you, Chairman. Thank you, Senator Orr, for putting this bill in. But I'd like to, more of a statement and concern moving forward. I'm a stakeholder, as many of my people that have contacted me. I am a landlord, and very soon I'm going to try and not be a landlord because of the lay of the land in the state of Rhode Island. I've owned property for over 20 years. I'm not a very rich person. I work very, very, very hard. I fix a lot of my own stuff. And one thing I learned early in the gate was the state of Rhode Island, the laws are against landlords and they lean towards tenants. It's an unfortunate truth. And that also plays in part of why our rental costs are so high in the state of Rhode Island, because of that unfair balance. You know, I'm not in it personally as a landlord to make any profit out of it. My thought going in as a landlord is, as being a self-employed person, I don't pay into retirement. I had nothing to look forward to when I hit my golden age of retiring. So what I thought is, I'll get involved in being a landlord and buying properties. I can work my hands, I can fix a lot of things and save money, which I did. But one thing I learned is, it don't work out as you plan. So I had a very, very difficult time prior to COVID. I made the decision to cash out. I'm not making any money. I'm barely breaking even in a time when the market is very high. I got lucky on that part. I had 5 properties in the last 2.5 years that I am getting rid of. Prior to COVID, this decision was made. I didn't do too good on the other 2, but the two that I got rid of on COVID, it ramified the situation of the trouble that was being caused. Landlords have to pay a mortgage, and when the mortgages are paid, the penalties are very, very, very extreme, and it's hard to get out from underneath. With COVID, I had tenants that were making more money being out of work because of COVID, with the stimulus that you just mentioned that they were receiving, far more than they would have working. And some of them tenants, knowing that they could not be evicted, and I had the house up for market, and we're getting money in coverage for the specific to pay the landlord for the tenants, refused to pay. In this last year, under COVID, has been the most damaging financial hit to me in my 20 years of being a landlord. And it was amazing to me that these people I know were making more money now under COVID and not paying their rent. So I know this is only under COVID, but like I explained, it affected me worse under COVID as a landlord with the penalties of not paying. And then to add injury to insult, we see some bills that are passed under COVID, like the voter bills, that it was just going to be because of the pandemic. Now those laws are trying to be reinstituted as, hey, this worked good, let's continue to do it. So that's my other concern. And I know, like I mentioned before, some of my tenants were getting rental assistance specific to pay for their rent, and they weren't giving it. So I am very concerned about this bill. I had many people call and email me, and that's all I had to say, I guess.
Thank you, Senator Rogers. Yes, Senator Raptakis.
Thank you, Madam Chair. I also I want to commend the sponsor for putting legislation in, because she's had received probably many emails and phone calls. But at the same time, I think the magic word is compromise. Is trying to find a compromise with this legislation to meet both sides. I also did receive a lot of emails, a lot of concerns. One concern was about somebody that was subleasing their unit because they got away with it. They could. So I think what we have to do is probably this might be a good time also to relook at a lot of these statutes. But I think the magic word on this bill is find a compromise for all to be satisfied at the end of the day. Thank you, Madam Chair.
I couldn't agree with you more. Thank you, Senator. Senator De La Cruz, do you have a question?
I wanted to also speak on this bill.
Go ahead. Thank you.
Thank you. So Senator Lombardi had brought up a great point with separation of powers, but I'd also like to point out that is it really necessary for this law when the executive order that enacted the moratorium would be sufficient in the future if we were to have another pandemic, which usually happens about every 100 years. So I question whether or not it's absolutely necessary to pass this law. I would also say that the Residential Landlord Tenant Act is heavily lopsided. It's in favor of the tenant, and it should really be balanced, but that's another topic for a different day. There was a time where the landlord-tenant laws needed to be enacted, but that is not the case today, as tenants often have more rights than the property owner. Providing a home, maintaining the property, and ensuring it's safe and suitable for habitation is often villainized in our society. Most landlords in the state own a few rental properties. They are not real estate tycoons, as some might imagine them to be. They're often your neighbor, and they too are just trying to get by, and they too have been adversely affected by the pandemic. I find it a little outrageous that to think that tenants get stimulus checks as well as unemployment supplemented to help them get by, and there is no basis for a landlord to insist on that money being used to pay back rent. Even the reconciliation program to see if the tenant can make up the payment is lopsided. So I would say consider this. If a tenant can't pay their rent, then landlords can't pay their mortgage. Banning all but essential evictions, such as like criminal activities, is, I would say, outrageous. And there is a better way. How about people who are behind on their rent must have their stimulus checks go directly to the landlord as representative payee. So I think there are so many better ways to deal with the crisis instead of creating an even bigger one. And what I mean by creating a bigger one is we can't just look at the immediate effect of the law, but also the subsequent effects, the domino effect. So I close by saying this. I have no doubt that the sponsors mean well. Absolutely no doubt in my mind. They are compassionate people. But this bill is flawed and will have a detrimental effect on housing, foreclosure rates, and homelessness. If we want to avoid that kind of destruction, we should vote against this bill. Thank you.
Thank you, Senator. Are there any other committee members who have a question? Yes, Senator Archambault.
Thank you, Madam Chair. First and foremost, may I be counted in the affirmative on any bills that I wasn't here for, and would you please acknowledge my attendance? To respond to the criticisms.
Senator Archambault, yes, you may, and it doesn't change the outcome. Thank you.
Thank you, Madam Chair. With respect to some of the commentary on the critical aspects of Senate Bill 183, and I commend Senator Oyer for her altruism and the heartfelt intent of the bill. Certainly we need to protect those most vulnerable, but as was said earlier by Senator Dela Cruz and others, there needs to be a balancing test, I think, so that landlords and people like Senator Rogers, who've invested their entire life into acquiring properties, are also part of the equitable balance. And so there's some work to be done, but I want to point out a couple of areas that were of concern to me. As a practitioner in the district courts, I'm there on a weekly basis, and prior to the pandemic, 5 days a week I'm in court, like Senator Lombardi. We practitioners who are in the trenches, and we're there all the time. And I can appreciate this correspondence that came from Julie Hamill with respect to the mediation program, the proposed eviction diversion mediation program. As Senator Lombardi said earlier, there is a separation of powers issue there. And one of the things that's going to have to be looked at is the mandate of 10 mediators and the training that goes with them. It's not in its essence an unfunded mandate. It may dovetail more into the separation of powers issue, but certainly that number and the ability to implement an eviction program is something that has to be looked at carefully, I think, when it comes to any implementation of this bill were it to pass. Because the district court is our busiest court. It has the highest volumes of 65, 70,000 cases a year. It's the trenches, and they're really dealing with a volume of cases on any given day. So that's an area I think that the budget has to be looked at. I will say also that my understanding is there's going to be $200 million in funds coming in that may help to assuage some of these concerns. We are starting to get on the far side of the pandemic. We're not there yet, right? Obviously, many in this meeting, I'm sure, don't have vaccinations yet. So, I mean, we're getting there, but it's an area of concern that has to be addressed, that being the mediation. Thank you for my thoughts.
Thank you, Senator Archambault. I don't see any other questions by committee members. Thank you, Senator Oyer. Next on the agenda is Senate Bill number 265 by Senator Coleman, an act relating to education, low and moderate income housing. Senator Coleman.
Thank you very much, Madam Chair, members of the committee. So this is a bill that incentivizes more construction of affordable housing by adding a modest amount more money to the school funding formula for cities and towns that have surpassed their minimum affordability mandate. So that's a little bit of history. Prior to 2010, state support to local education funding was determined in a non-formulaic way annually. So this typically involved applying a basic adjustment to the previous year's allocations for each city or town. This led to all sorts of disparities, as one might imagine. So when the Obama administration passed the Race to the Top initiative, one of the requirements was to participate in the establishment of a funding formula. Rhode Island obviously did that. It was done in 2010 here, and it exists in General Law 16-7. But because school funding is based largely on property taxes, communities with a lot of affordable housing potentially lose out on some of that revenue source for their schools. Although the funding formula also provides for lower income levels to a modest extent, it adjusts each municipality's allocation based on the percentage of the students who are receiving free or reduced lunch. But this bill basically exists to even out or to start evening out some of the disparities within the funding formula for schools, which is based on property tax. So with that, happy to take questions.
Thank you, Senator. Any questions from committee members? I don't see any at this time. Thank you, Senator Coleman. Next bill is Senate Bill number 413 by Senator Quesada, an act relating to businesses and professions, real estate brokers, and salespersons. Senator Quesada.
Thank you, Madam Chair, and thank you to member of the committee. This bill is, it just would require all brokers and salesperson license to submit and pass a writing examination to include topic as fair housing. And what it means is they want, it was submitted, it was voted to me by the Brokers Association, and they just wanted most of the brokers and salesperson to be able to take 24 hours class on fair housing and to be able to provide better information to the to the person who buying a property or interested in buying a property, and they have to do this class every time when they have to renew their license, and I believe it's a 24 hours class, and they had to write taking a test on this issue. And we'd be more than happy to take any question, but it's just to make sure that they had knowledge about fair housing to be able to sell properties. Thank you.
Thank you, Senator Quesada. Any committee members have any questions of the senator at this time? Okay, very good. Thank you. The next bill is Senate Bill number 523. I don't see Senator Paolino on the call. This is an act relating to taxation, collection of taxes generally. It prohibits the tax sale of properties when litigation is pending disputing the amount owed. If Senator Paolino comes on during our hearing, I'll make sure that we hear from him. Next bill is Senate Bill number 524, an act relating to towns and cities zoning ordinances by Senator Coleman. Senator?
Thank you, Madam Chair. So this bill increases in lieu payments from $40,000 to $75,000. So an in lieu payment happens when a development is required to include affordable housing as part of its zoning. So for instance, a zoning permission may be granted for a 100-unit mill redevelopment, of which 10 units are required to be affordable. And so in some instances, developers can pay what's called an in lieu fee instead of developing the unit. So they basically give the money to the city or town. The city or town puts the money into a restricted account, a city pot of money that supports affordable housing initiatives. So basically, it's a way for the developer not to build the unit itself, but to sort of pay out of it. So this bill, in recognition of increased housing costs, increases the in lieu fee. And it also gives cities and towns a little more time to use the money in the pot. Currently, the law is 2 years, which is very fast because some of these housing developments take a lot longer than 2 years to build. It's insufficient because projects take a long time to get off the ground. Happy to take questions.
Thank you, Senator. Any questions for Senator Coleman? Okay, no questions at this time. Thank you, Senator. The next bill is Senate Bill number 528 by Senator Mack, an act relating to property, residential landlord, and tenant act. Senator.
Hi, thank you, Chair. And I'm excited because this is my first bill in my first session. And so I'm really proud to be able to sponsor a bill that is something that my family was directly impacted from growing up, as my mother faced an eviction and it made finding housing really difficult for her growing up as one of 5. And I firmly believe that housing is a human right and that we should eliminate as many barriers as possible to everyone in our state acquiring quality, affordable housing in our state. This bill will not prevent evictions from being filed or being started. That's what I want to get out the way at first. It will, however, prevent an eviction that is not yet fully through the court system or that is not fully resolved from following a tenant who is then in the search of finding housing. Lots of folks are evicted either through retaliation or through not through the official court process, through what is called a self-help eviction. There is a power imbalance right now. I believe it was Senator De La Cruz who talked a little bit about the imbalance of the Landlord-Tenant Act. But yes, there is an imbalance when someone who has the right and who has the power to send you onto the streets, they can change your locks overnight, they can shut off your energy, and they can make your life a living hell. This is the power imbalance that some people, and not all people, will utilize in order to make sure that a tenant does not have access to rights. An eviction will, again, not be prevented from being filed in the case that the landlord has done a rightful eviction, or in the case that a tenant has fallen through on their pre-agreed upon agreements. We need to also make sure that when we're thinking about this bill, we're thinking about the racial justice impacts. There are a lot of stereotypes that exist when we think about people who are facing evictions. We've heard a few of them tonight. They are lazy. They don't have money. They are willfully not paying for housing. These are just simply untrue, and this is a product of stereotypes and biases that we have towards people and that we use to demonize the poor. If we firmly believe that housing is a human right and that everyone in our state should have access to quality and affordable housing, we need to make sure that we're removing barriers, including making sure that until an eviction is completed, it is sealed so that folks do not have that as an additional barrier. And if we also believe that innocent until proven guilty, an eviction that has not yet fully gone through a court process should not be impacting someone's ability to housing. Thank you, and I look forward to your questions.
Thank you, Senator Mack. Are there any questions for the senator? Yes, Senator Archambault.
Thank you very much. I think that the intent of the bill is laudable in that it's trying to prevent people who are aspiring to get rental property from being discriminated against. That said, my critique is entirely separate from that. It has to do with the courts. I've had the opportunity to talk at length to the administrators of the courts, the district courts, where this will be implemented, and perhaps this is some food for thought for the senator in trying to incorporate this into some language that would make it effective. And that is the implementation of sealing and unsealing. The courts aren't set up for it. They don't have the ability to seal the bill, unseal the bill. They don't have the staff set up for it, number one. And number two, it's an issue of potential civil liability. When a bill is unsealed, you have the exposure for potential civil liability. These are very real concerns from the highest levels within the courts. So something has to be thought out. I know the bill is short. It sounds like it's succinct and to the point, but there's a very practical administrative aspect with this bill's implementation in the courts that has to be addressed. Thank you.
Thank you, Senator.
I'm not sure if that was a question, but I do know that Jordan McMahon and Jennifer Wood from the Center for Justice will be on. They've worked on this bill in the past, and it was also heard in the House last week. So I look forward to them being able to respond to you, Senator Archambault.
Thanks. May I follow up?
Yes, Senator.
It wasn't a question, respectfully. It wasn't a question. It's very real concerns that I'm bringing to your attention from the courts that have to be addressed, irrespective of anything to do with Center of Justice or any of those other places. It's a good bill. The intent is good, but in order to make it work, there's some mechanics you're going to have to work out. That's all. It was for your benefit with working with the bill.
Thank you to both senators. Any other senator have a question for Senator Mack at this time? Yes, Senator De La Cruz.
Thank you, Chairwoman. I actually don't have a question. I have a statement. about the bill. As I recall, this was Senator Metz's bill last year, and I did vote in favor of it. I do have some concerns, as Senator Archambault stated, but I would like to point out, I believe, as the senator had stated, that landlords can landlords can change the locks and shut off utilities. That is against the law. Any landlord that does engage in that kind of behavior would be found, obviously, guilty of such behavior. So that's a misinformation there. But thank you.
Thank you, Senator. Yes, Senator Quesada.
I just want to make a comment. It's not a question. Yes, that's true. That was Senator Med bill last year. You know, for everybody who don't know, I work for the city of Providence, and one of my jobs is to visit many of these houses when tenant make a complaint against the landlord. And one of the things is it is against the law if your landlord changed the lock or disconnect any service to a tenant. They cannot do that in Rhode Island. It's true what Senator Mack just said. Some landlords, you do use this against the tenant. I see many cases, a bad tenant, bad landlord. You see both. It's not just one side. But at the same time, it does happen. Many times I have to call many landlords to make sure that they connect the water or any service that when they try to do an eviction by themselves. It happened. I'm not going to say it's not happening before, but as soon as we call them and we explain to them this wrong, that you have to take those tenants to court for them to be able to evict them, usually at work, and usually landlord put the service back. Sometimes they do it for ignorance or because they are frustrated because the tenant be living there for 6 months without paying the rent because of right now, especially with COVID-19, that's most of the excuses that most of the tenants have not to pay the rent. Then I seen both cases. Believe me, I've been working for the city for 19 years doing this work, and I had a lot of experience on this, and I seen it all. Then I want to thank Senator Mack for putting this bill in. It's happening on both sides. Thank you.
Thank you, Senator Quesada. Yes, Senator Reptakis.
Quick comment and question. If this bill is similar to what we passed last year, what's the difference? I thought I heard Senator De La Cruz said that we passed something similar. No?
No.
Not the Senator Metz's bill? Was his?
No.
Okay, so I don't know why Senator, did I hear correctly? She said that we voted and passed a bill similar that was same content?
This is a new bill.
Okay. But was it addressing the same problem? It's addressing the same problem as something that we passed last year?
I don't have that bill up in front of me, Senator, but I can certainly...
The sponsor.
So I believe the bill that you're referring to, sorry, let me pull up my email, is last year's Senate Bill 2264, which was slightly different than this version. This version matches the House version that was heard last week by Representative Alzate, and it is being worked on by a number of organizations, including the Center for Justice and Homes RI, who will be able to speak more in depth with their lawyers and be able to answer any other questions. But the bill last year was 2264.
Which was a Senate bill, correct? The Senate version.
Yes, Senate Bill 2264.
Thank you, Senator. Thank you. That helps. Thank you.
It's held for further study in this committee.
Thank you, Senator Reptakis. Any other questions of committee members? Okay, very good. Thank you. The next bill is Senate Bill number 561 by Senator Coleman, an act relating to property, Rhode Island Fair Housing Practices Act. Senator Coleman.
Thank you, Madam Chair. This bill has also passed out of the Senate a number of times. Basically, the bill makes it illegal to discriminate in housing issues against someone with a lawful source of income. So in practice, it means that landlords cannot discriminate against potential tenants for a source of income that is like disability, medical, or veterans assistance, or the like. This does happen a lot. So 15 states, including Massachusetts, Vermont, Connecticut, and Maine, prohibit landlords from discriminating against potential tenants on the grounds that the landlord has a bias against the tenant's legal source of income. This is called source of income discrimination. It's often literally impossible for recipients of federal housing vouchers, so the former Section 8 program, which is now called the Housing Choice Voucher Program, to find an apartment to rent. Unlike neighboring states, it's perfectly legal in Rhode Island for a landlord to put in an apartment advertisement that says no Section 8 or no Housing Choice Voucher. So a prospective tenant with an unblemished credit history, who always pays rent in full, on time, who's never been evicted, who has perfect references, cannot even apply for the apartment. This is not right. This is the problem that the bill seeks to solve, to both make it illegal to discriminate in such a way and also eventually, hopefully, to destigmatize. Happy to take questions.
Thank you, Senator Coleman. Any other questions of the senator? Okay, I don't see any at this time. You do have another bill that follows that, which is Senate Bill number 563, an act relating to property, Rhode Island Fair Housing Practices Act.
Thank you, Madam Chair. I feel like I'm taking up all the space on this committee tonight. So this act would do two things. So first, it amends the definition of sexual orientation in regards to fair housing practices. It removes some very outdated language. It also allows for some procedural changes in the case of a dispute. Disputes around housing often come both under the Fair Housing Act and other laws. So those changes make the procedure for Fair Housing Act claims conform with the other laws that the state enforces. And also the act repeals the exemptions for discrimination based on sexual orientation, gender identity, or gender expression, which are currently exempted under law.
Thank you. Any questions for Senator Coleman? Okay, I don't see any at this time. Thank you, Senator, for joining us this evening. Next is Senate Bill number 501 by Senator Oyer, an act relating to state affairs and government, tourism, and development. Senator?
Thank you. This is really about addressing some issues with third-party rentals. This is a huge issue that affects housing in my district and the district of many coastal communities, is third-party rentals displacing year-round rentals. I know in the city of Newport, they've done a lot to try to make sure that they're trying to regulate them appropriately so that they can find that appropriate balance between and to meet the housing needs of the residents. Unfortunately, because of the expansion of the technology, it's been incredibly difficult and time-consuming for the local municipalities to try to keep track of, you know, where all of the third-party rentals are being posted. So this bill is really about creating a mechanism on the state level that will aid the municipalities in trying to keep track of these third-party rentals. So what the bill does is really asking the Department of Business Regulation to create a registry and a database on the state level. That will help the local municipalities be able to keep track, make sure that, you know, for tax purposes and other registration, public safety purposes, they are able to, you know, keep track of those individual registrations based on the state level registry. So that's, you know, it's a pretty short bill, pretty simple bill. I know that the Department of Business Regulation, I believe, either submitted testimony or is going to provide public comment. I do have a meeting set up with them to discuss their concerns, and look forward to any other additional testimony tonight. And I'm happy to take any questions.
Thank you, Senator Oyer. Any questions from our committee? Okay, no questions at this time. And Senator Oyer, you have the last bill on the agenda this evening, Senate Bill number 504, an act relating to businesses and professions, hotels, Unlicensed Rentals Act.
Yes, thank you, Chair. This bill is a little bit different, also trying to address the concerns that third-party rentals have raised for the local communities. And I'm working with the Rhode Island Hospitality Association on this bill. Really what it's doing is trying to level the playing field and also make sure that there's public safety and health taken into consideration when folks are renting out their property. So it creates a system of oversight, so that way when people are renting out their properties and really treating their properties as a hotel and as a commercial property, that there are components of it that will regulate it in the same manner to have public health and safety concerns considered. And this is a bill that I believe that Sarah Bratko may be on tonight to talk about this more, but I'm also happy to answer any questions.
Thank you, Senator Oyer. Any questions? Okay, no questions for you, Senator. Thank you very much. At this time, we will now go to the testimony from the public. For those members of the public who are signed up to testify, if you would kindly state the bill number you are testifying on, we would appreciate it. Just a reminder, we have over 100 witnesses. So for the purposes of an equitable apportionment of time and resources, I ask that you keep your testimony to 3 minutes or less, please. We do want to accommodate all who have signed up in advance to testify. I also want to thank my colleague, Vice Chair Archambault, for his assistance this evening. He will be joining us here at the rostrum at times during the evening. So with that, I would like to return back to the first bill on the agenda, which is Senate Bill number 443 by Lita McCaffrey, an act relating to health and safety, the Hospital Conversions Act. Let's see. I believe the first witness to testify will be Jennifer Hawkins from One Neighborhood Builders. Is this Ms. Hawkins?
Hello.
Welcome to the committee.
Thank you. Thank you for taking my public testimony today. Jennifer Hawkins, Executive Director of One Neighborhood Builders. For those of you who aren't familiar with our nonprofit, we develop affordable housing, engaged neighbors across greater Providence to cultivate safe, healthy, and vibrant communities. Since our founding in 1988 as the Onlyville Housing Corporation, we've developed 627 affordable homes. And we're the backbone for the Central Providence Health Equity Zone. So first, I just want to offer my credible, strong support for Senate Bill 561, an act relating to properties of the Rhode Island Fair Housing Practices Act. It's wonderful that the House has approved this legislation, and I'm hopeful that the Senate Judiciary Committee will also vote this out of committee, and ultimately that the Senate will approve this important legislation to remove source of income discrimination. Secondly, I also want to offer my support for the for Bill number 443, the Hospital Conversions Act. As mentioned, we're the backbone of the Central Providence Health Equity Zone, and so we work to address the social determinants of health. And so that's really all the, living wage employment, affordable housing, quality child care, the 80% of the reasons that really predict health and life expectancy. So I'm just want to mention the importance of strengthening the community benefit agreements. And as Rhode Island analyzes the proposed merger between Lifespan and Care New England and Brown Warren Medical School, that you really strongly consider requiring community benefit to be a mandatory consideration of deliberations. We would be pleased, One Neighborhood Builders, my colleagues that will be providing testimony tonight, to study this issue and to kind of share some proposed language around how to strengthen the community benefit agreement as you consider mergers. Thank you for listening to my testimony tonight.
Are there any questions of Ms. Hawkins by any committee members? I don't see any. Thank you so much for your testimony this evening, Ms. Hawkins.
Thank you.
You're welcome. Next, we have Mr. Emmanuel Falk from SEIU 1199 New England. Welcome to the committee.
Thank you, Chairwoman Coyne, members of the committee. Emmanuel Falk, SEIU 1199 New England. We represent 4,500 workers in Rhode Island, including over 2,300 members at Women and Infants and Butler hospitals within the Care New England system. We strongly support S443 introduced by Leader McCaffrey. We are, as everyone knows, we are looking at potentially huge merger between the largest private sector employer in the state and the the third largest private sector employer in the state. So if this goes through, it is going to impact the entire state economy and pretty much touch every Rhode Islander that accesses health care. So we think S443 is really good because it further strengthens the Hospital Conversion Act, which is a national model for protecting the public, workers, and patients during the acquisition of hospitals and hospital systems. We think that this process should go really slow and be deliberate, and we think the extra criteria added by the legislation makes a lot of sense. I know there's 100 people going, so I'm gonna keep it short. I do want to point out one comprehensive study by the National Bureau of Economic Research, which was updated in 2018, and I'm just going to read right from it. Prices at monopoly hospitals are 12% higher than those in markets with 4 or more rivals. After mergers occurred, we find that prices increased by over 6% if the merging hospitals were close neighbors, less than 5 miles apart. Rhode Island Hospital and Women and Infants, as we know, are less than a football field apart. So I think it is incumbent on all political leaders, stakeholders in this process as the merger moves forward. If it is to happen, it needs to go slow, and we need to have guardrails for the community, for workers, and for all the patients of Rhode Island. Thank you.
Thank you, Mr. Falk. Any questions of this witness? Okay, very good. Thank you for joining us this evening. Thank you for your testimony. Next.
Thank you.
Next will be Ms. Brenda Clement from Housing Works, Rhode Island. Welcome, Ms. Clement. Welcome to the committee. Ms. Clement?
Yes, thank you, Madam Chair. Thank you for the opportunity to speak. I'm here to speak directly on Senate Bill 443, but did also want to note that I have submitted testimony for a number of the housing bills, and as always, happy to answer or address any questions from the committee. As a couple of my colleagues have already mentioned, the opportunity of the merger application before our state for our two healthcare systems provides a very unique and great opportunity for us to address some long-standing issues that we've seen. We were working well before the pandemic on social determinants with a number of our housing and healthcare qualities. We know that your zip code matters for lots of reasons, but particularly for your health and educational outcomes and attainment. So we thank Senator McCaffrey and the other bill sponsors for submitting this bill, and we urge members of your committee to act on this bill to require the applicants to provide critical community information and other information as the bill outlines for review by Department of Health and the Attorney General. We also think that we should add more criteria and also more specific authority for both Department of Health and the Attorney General to require the merged entities to make meaningful investments into addressing some long-term inequities in our healthcare system. So as my colleague Jen Hawkins mentioned, we're happy to work with the committee members on trying to put together some more details about that direction, but welcome the opportunity to improve health outcomes. Our goal is a triple aim: to improve population health, enhance quality of care, and implement overall system cost reduction. And I think this merger application gives us a rare opportunity to do that. Thank you for your time.
Thank you, Ms. Clement. Any questions from the committee members for Ms. Clement? No questions at this time. Thank you for joining us this evening.
Thank you.
Next, we have Ms. Gayle Robbins from CARE, New England. Welcome to the committee, Ms. Robbins.
Thank you. Good evening. My name is Gayle Robbins. I am the Senior Vice President at CARE New England for Planning and Finance. And I just wanted to go on record tonight, have the opportunity to state that CARE New England has no opposition to Senate Bill 443. We find it not unreasonable, and will certainly comply with any required and requested information in support of the hospital conversion. There's not a lot of commentary that I have at the moment about the merger in particular, but if there are any particular questions that the committee has, I'd be more than happy to do my best to address those.
We appreciate you joining us. Any questions for Ms. Robbins? Well, thank you for joining us. There are no questions at this time. Thank you for your testimony.
Thank you very much.
You're welcome. Okay. Next, we go on to Senate Bill number 131. I believe we have Stephanie Barabucci on the line. Welcome to the committee.
Hi, my name is Stephanie Barabucci. I am a housing provider in the state of Rhode Island, and I am calling to oppose 183 and 528. These bills are detrimental to small housing providers like myself. I'm a single mom, and I can tell you that many of my tenants during COVID did not pay rent, and I worked with them through COVID. And I had to carry 4 mortgages as a single mother through this pandemic. My bills are a minimum of $6,000 a month for my houses. Us landlords are not rich people sitting in a cigar bar. We're single moms. We're working CNAs. We are nurses. We are just your everyday average people trying to make it by. So I ask you to please oppose these bills because it would severely harm people like me. I also mentor a lot of people to invest like I did, and the millennial population, most of us are buried in student loan debt, and our only opportunity to own a home is to buy a multifamily home. And these bills severely restrict us when somebody is not paying. They severely restrict us from being able to get somebody in the unit who can pay us, and so we can pay our mortgages. Most of us have an insane amount of bills to pay. We don't, I think Senator Mack was very, very misinformed when she said that, people are changing locks and shutting off utilities. We're not allowed to do that in Rhode Island. It's illegal. And most of us know that. Most of us have good intentions. But you can't demonize us as housing providers. We're everyday people just trying to make it by like everyone else.
Thank you, Ms. Babucci. Does anybody have any questions? Any committee members have any questions of this witness? Well, thank you so much for calling in, and thank you for your testimony. We appreciate it. Next up,
thank you.
Mr. David Sisson. Welcome, Mr. Sisson. What's that?
Hello.
Hi, is this David Sisson?
This is.
Yes, welcome to the committee. You're here to testify on Senate Bill 131, I believe.
Thank you. Just want to say I'm opposed to these bills. I'm a local small business owner and a small-time landlord. I only have one residential rental. But my wife and I have invested in rental property in order to help our daughter go to college. And I believe these bills are going to make it harder for us to protect our investments, and also harder for us to provide quality housing for our renter. I think the intent of these bills will backfire, and I believe that these bills will make it harder for landlords to do business, and also harder for us to provide quality housing for our good tenants, and make it easier for bad tenants to take advantage of us. I'd encourage you guys to vote no on this. Thank you.
Thank you, Mr. Sisson. Any questions for Mr. Sisson? Thank you for joining us this evening.
Thank you.
The next bill we'll now jump to is Senate Bill 183. Jennifer Wood from the Rhode Island Center for Justice. Welcome to the committee, Ms. Wood.
Thank you very much. And thank you, Madam Chair and members of the committee, for the opportunity to testify on House Bill, Senate Bill 183. This bill really, I'm here to testify in support of the bill. It does two very important things. It creates a foreclosure and eviction moratorium during a state of emergency, but it also importantly creates a second and longer-term solution to some of the issues of homelessness and housing instability in our state by creating a mediation diversion program for eviction cases. And why do we need a moratorium during this ongoing pandemic would be one of the first questions I think most people would have about the bill. I'm sorry.
You're still there? Go ahead.
Oh, I'm sorry. So the reason that we need the moratorium is that the federal moratorium is going to end, and we need room for rental assistance programs that are available in Rhode Island to work. I've heard a lot of consternation, and I think it's very valid, about landlords that need help because when their tenants can't pay their rent, they still have to pay their mortgages. There's $200 million in rental assistance in Rhode Island right now, and based upon the American Rescue Act, another $200 million will be coming to Rhode Island in the next year. Over the last month, $15 million have gone in payments directly to landlords. The payments do not go to tenants. They can't be misappropriated elsewhere. These rental assistance payments go directly to landlords, and the whole purpose of the moratorium is to stabilize the situation so that both landlords and tenants can be kept safe during that period. Quickly, just to touch on the importance of the mediation program, 80% of all cases settle out of court, and we've heard some very important comments from Senator Archambault and others who practice in the district court. There is a high volume of cases, 65 to 70,000 cases a year. If a lot of that volume can be redirected to trained, capable, and mediators who are well-versed in housing law, they will be able to help the parties resolve their matters. It will save costs for both parties. It saves costs in the court system. And there will be knowledgeable, neutral parties that can take a tremendous amount of that volume and save people days out of work and a lot of headaches and just get a lot of these cases resolved. It happens in the Superior Court. It happens in the federal court. These mediation programs are adopted around the country and extremely successful. In this legislation, the mediation program is modeled on successful programs in Connecticut and Massachusetts that have proven the ability to resolve so many of these matters at lower cost and less distress to the parties. So thank you for the opportunity to testify in favor of this legislation. I know there will be a lot of questions, and I really look forward to working with all of the interested parties to arrive at the kinds of compromise that people have talked about this evening to have the best solutions to stabilize housing in Rhode Island, make that federal rental assistance available so landlords will be remaining economically stable during the emergency and beyond, and also putting in place a permanent mediation program to address some of the volume of these cases at a reasonable cost and at less distress to the parties.
Thank you.
So thank you for the opportunity.
Thank you, Ms. Wood. Any questions of this witness? Okay, I don't see any at this time. Thank you for joining us. Next up will be Jordan Mickman from Rhode Island Center for Justice. Welcome to the committee, Jordan Mickman.
Hi, thank you for having me. My name's Jordan Mickman. I'm the supervising attorney at the Rhode Island Center for Justice, and I'll keep it real quick tonight. This bill before you, Senate Bill 183, is intended to take the lessons learned from the past year and implement a predictable legislative mechanism to maintain housing stability during a state of emergency. During the last year, we've had all three branches of Rhode Island government, as well as various agencies of the federal government, create all sorts of different programs, which have created a lot of confusion and loopholes for different types of people, depending on different types of circumstances. So what this bill does is it takes all of the lessons we've learned and all of the various types of programs that we put together into a clear, predictable thing that will exist in a state of emergency. So I just want to take a second to remind all of the opponents of this bill and everyone who's so angry about this that this bill is expressly limited to a state of emergency. During a state of emergency, we do not need to be worrying about all these problems. We don't need tenants worrying about things. We need to make sure that our community is safe and make sure that people have access to the things that they need to get to. I also just want to remind folks that the Landlord-Tenant Act is by no means stacked in favor of tenants in Rhode Island. 9-day eviction cases are the only type of civil action process that gets heard within 9 days. It's an expedited process that favors landlords. There's a lot of misinformation out there, but certainly not enough time to address it in 3 minutes tonight. But the two components to this bill. One, during a state of emergency, there will not be evictions. It's not an absolute bar to any evictions. What it says is evictions may still proceed for criminal reasons if there's criminal conduct going on or any conduct at the apartment that's impacting the health or safety of the tenants, the landlord, or the public. So it's not taking away any method for enforcing rules and contracts and laws. What it's saying is that people will not become homeless during a state of emergency. The mediation program is an eviction diversion program that is exactly what it sounds like. It is intended to keep people out of court when their housing is on the line. We all know that going to eviction court has major long-term repercussions for folks who are seeking housing. And the point here is that mediation works. Alternative dispute resolution, arbitration, these are things that have been adopted internationally and across the country by big businesses that are forcing consumers into these small things all the time. And the truth is they work. People get to the table. Before they hated each other, but then they sit down with a mediator who listens to both sides tell their story. And I've sat through mediations myself personally, and almost every single time you reach a resolution there. So this is something that I can personally say is something that will avoid evictions while also preserving both sides' rights. I'll leave it there.
Thank you. Thank you, Mr. Mickman. Any questions for this witness? I don't see any at this time. Thank you so much for your testimony. Next will be Keith Fernandez from the Rhode Island Coalition of Housing Providers, Providence Apartment Association. Welcome to the committee, Mr. Fernandez.
Thank you very much, Chair. Good evening. And to the rest of the members of Senate Judiciary. My name is Keith Fernandez, and I am the president of the Providence Apartment Association and one of the founding members of the Rhode Island Coalition of Housing Providers, the same folks that you have been hearing about from tonight. So there's plenty of us on testimony tonight, and I have a couple of comments to make. We've been listening into the testimony. I oppose 183 and 528. 183 has been a mishmash of certain things, and even the sponsors are not sure as to what's in the bill. For example, they say, just if I look at the bill correctly, it says, during a state of emergency, you're not allowed to evict anybody. There's no mention of whether it's a health emergency, whether it's a flood in West Warwick, which we have to declare a state of emergency for federal funds. There is no such mention of anything. She went on live TV yesterday on Channel 12 and said, well, there's funding for landlords, so landlords are not affected. There's no mention of funding in the bill. And then it further goes on to say that it has to be mandatory mediation. And she says that you have to have mandatory mediation so that we can disperse this fund of $200 million that has just come in to the state of Rhode Island. But then she goes on to say that the mediation program is going to be permanent. So are we suggesting that the federal government is going to subsidize all the landlords forever if mediation is permanent? It's completely disingenuous as to how they have been portraying this bill. What is written in the bill and what is being said is absolutely two different things. So they want to deal...
And that's why we have these hearings too, Mr. Fernandez. So, you know, I appreciate your testimony. Is there anything else that you would like to add?
I would just quickly touch on Bill 528.
Yes.
The sealing of the eviction. That's another bill that's forcing landlords to come back after filing a stipulation. 70% of cases are stipulation cases. They know landlords won't come back. The net effect of that is I won't be able to know who I'm putting in my house. I'll tighten my credit standards, I'll tighten my job standards, and it'll make it harder for the next person who's doing the right thing to have safe, affordable housing. So I urge all of you to please vote against these bills. Thank you very much.
Thank you. Any questions for Mr. Fernandez? Thank you, Mr. Fernandez, for your testimony. Next up is Etienne Cote. Good evening. Good evening and welcome to the committee.
Hello?
Yes, welcome to the committee. You're on to testify on Senate Bill 183.
Oh, 183. Okay. My name is Etienne Cote. I oppose Bill 183, also 528. And so I am a small business owner in Providence, and I own 2 rental properties. And the biggest misconception that we need to abolish is the misconception that landlords, really housing providers, because that's what we do when really no one else wants to do it, that we're wealthy people of the majority that, have options and are able to deal with some of the delays and the red tape that I believe this bill adds to the process. So I'm a minority, a black man from first generation of Caribbean and West African descent. I cannot afford a single-family home, but I'm willing to do the work, and that's the primary thing. We're willing to do the work that other people aren't willing to do to provide safe housing. And right now, I think a gentleman said that it's in favor of the current system is in favor of the landlords. That's far from the truth. Ask any landlord who has tried to go through an eviction. If you're able to successfully do it, how do you get your money back? You don't. You're out thousands of dollars. I can tell you that I'm out thousands of dollars anytime I've had an eviction. So what I've done is reduce my rents to well below market rate because I'm a person in the community, and the community is important to me, and I want to give people a fair shot, but it's a way to get the best person possible, but it's obviously not very affordable to do that. So that is a big issue. And in terms of the mediation, we're adults. People sign a legal agreement, and if someone's not paying, we know the relationship already. We know the culture of the house. Sometimes tenants are disturbing other tenants. There's a range of issues why we would go to the last very cumbersome and uncomfortable resort of eviction. No one wants to go to eviction. But if we do that, we know what we're doing. We don't need a third party to come in and add layers of bureaucracy and red tape and costs. So who pays the rent during that time? I haven't heard about that. So I think we just need to maintain the same process, and I think things should be, if anything, a little more, in landlords' favor because we're providing housing, and it's a housing shortage. It's an issue, and we're at the table to help alleviate those concerns.
Thank you.
The only other thing this bill would do is add a lot more scrutiny because we wouldn't be able to give people a chance. If we have to wait and go through, this mediator and that person before we could, once again, we already made our decision. We can't have the person here. We have to get someone that could pay. That's it. We're property managers. We understand the dynamics of the property. This mediator doesn't know the relationship, doesn't know what the tenant's doing. We're not going to try to prove that they committed a crime and all that. We understand that we want tenants. I don't want to ever evict someone. A turnover is very expensive.
Thank you,
Why would I ever want to do that?
Thank you, Mr. Cody. We have 100 people lined up to speak.
Sorry
That's
about
okay.
that.
No worries.
Thank
you very much for your testimony, and we appreciate that. Any questions of Mr. Cody?
Great.
Thank you. Next is Mr. Gregory John Rice. Good afternoon, Mr. Rice. You're here to speak on Senate Bill 183.
Yes, ma'am. Hello, everybody. My name is Gregory Rice. I am 30 years old, and I currently own traditional small multifamily style housing in Woonsocket, East Providence, Warwick, and West Warwick. I firmly believe that there's a severe need in the state for well-kept and properly managed rental units. It is known that Rhode Island is in need of affordable housing, and I believe this bill will only further the state from achieving this goal. In addition to my own portfolio, I'm also a property manager in Pawtucket. The current legislation being proposed fails to address how myself as a small landlord will be able to pay my mortgage, taxes, insurance, utilities, repairs, management company, maintenance vendors, and beyond. Typically, when a tenant doesn't pay, we head to court and work out a payment arrangement or agree to a voluntary move-out stipulation. It is very rare that we can't reach a compromise with the tenant and the case has to go to trial. This proposed bill includes mandatory mediation, which will double the time at least needed to process an eviction and add further cost, oversight, and management to the state, which I'm sure the state does not want. What the state is failing to realize is that most landlords do try to work a deal with tenants prior to an eviction, and if that deal can't happen, landlords do so at court. And like I said previously, it's rare that a voluntary deal cannot be made and a case has to go to trial. This shows me that a clause for mandatory mediation is only further adding a burden to not only the landlords, but to the tenants and the judicial system as a whole. Also, the state of emergency clause is also worrisome because it casts a wide net, meaning if there's a flood in Riverside, then the tenant in Providence wouldn't have to pay their rent. So as written, this bill shows it's too cumbersome and has not been properly vetted. Finally, this bill puts in jeopardy the entire banking system, third-party vendors, the communities these properties are in, and the future of property investors. If the banks aren't being paid, society will feel those effects quickly. On top of that, those in the contractor and construction fields will get shortchanged because landlords won't have expendable monies to spend on repairs. These factors will create a toxic cocktail of properties slowly becoming distressed, property values decreasing, crime increasing, and tax revenues dwindling. Roughly 40% of the state's housing stock are rental units. I urge you to please consider that the decision presented to you today has the ability to create a lasting negative impact on the entire state in the very near future. Thank you.
Thank you, Mr. Rice, and I appreciate your concise and organized testimony. Does anybody have any questions?
Thank you.
Okay, thank you. Next is Mark Santos. Good afternoon, Mr. Santos. You're here to testify on Senate Bill 183.
Thank you, Madam Chair. I appreciate the time and those committee members as well. I'm in opposition of Senate 183, housing providers, and the reason is even during a pandemic, housing providers need to reserve the right to evict the tenant to protect the other tenants in the building. And so I think the unintended consequence of this law is that we're going to harm the good tenants in a building if we have a negative or disruptive, threatening tenant in that case. And we need the right to be able to do so. I'll give you just a quick example. If you were living in a multifamily yourself with your children and another tenant, one that you may see every day in the hallway or out in the parking lot or in the laundry room, if they're threatening you or exhibiting disruptive behavior, I know this bill stipulates that if somebody feels threatened or unsafe, that you can still pursue an eviction. However, put yourself in their shoes. If you're living in the same building, how likely are you to implicate somebody that you live next to and are going to be living next to for several weeks or months while this eviction process is ongoing? So again, we want to try to protect the good tenants. I'll give you just a very quick story to illustrate this. This is a real world story that happened to me during this pandemic. We had a tenant who brought bed bugs into a 6-family building, and this tenant refused to comply with the treatment plan, the pest treatment plan that I paid for. And as a result, we were unable to get rid of the bed bug infestation. So imagine living in a building where one tenant refuses to comply with that order, and you're sleeping in a bed getting bitten, your arms, your legs, all throughout for months and months because somebody cannot evict the tenant. So we need the right to be able to do so. And one last point about eviction diversion. My point is it's a redundant system. It already exists. So if you go to the second floor of the district court in Providence, you'll see mediation. Prior to going into the courthouse, the attorney, the plaintiff, the defendant are sitting there attempting to work out a deal in the form of a stipulation.
I think we're losing you, Mr. Santos.
Which is, I'm sorry, I'm actually
I think we're losing you
right now. I'm at one of my properties right now. Can you hear me okay?
Yes, please finish up.
Okay. So the eviction version is already occurring. So you're on that floor of the house, you see it happening every day. And the reason we need a stipulation and we don't need this additional layer is because it'll prolong the time it takes to get a bad tenant out, all the while we're going without rent. And so the mediation is already occurring. It's with the attorneys, the plaintiff, the defendant. The judge signed off on a stipulation.
Okay, I think.
Don't adhere to it, then we go forward from there.
Thank you, Mr. Santos. Yes, thank you. Any questions for Mr. Santos? Thank you. Next. I believe we have Adriana Jasmine Bonilla on the line. Good afternoon and welcome to the committee. You're here to testify on Senate Bill 183.
Correct.
Yes, thank you. Go ahead.
Permission to speak?
Yes, you may.
Okay. Good evening, Senators. Thank you for hearing my testimony today. My name is Adriana Bonilla. Approximately almost 2 years ago, I gave birth to my son. During this time, I was not able to collect any TDI due to the fact that I am a 10-month employee. I have summers off and do not receive any form of pay. While being out on my maternity leave, I was not able to qualify for disability since I was 3 months pregnant. They considered me to have a pre-existing condition. In simple terms, I would not be able to receive any disability money. I was one of the newer employees, so I had used all of my accumulated time, and then I went with no pay. During this time, I still had to pay for my union dues, disability, medical insurance, which includes myself, my husband, and my son. All of these dues that normally came out of my check now came out of my pocket. In conclusion, I ask you to oppose Senate Bill 183 and 528. These bills are detrimental to landlords with adding extensions of non-payment and mediation. This would be government overreach when I, the landlord, and the tenant already have an agreement. Thankfully, I am able to live in this home and provide housing for my tenants. If this bill is to pass, this may no longer be a reality. Many of us landlords have come from humble beginnings, put in hard work that later allowed us to now be homeowners. Once again, thank you for your time.
Ms. Bonilla, thank you so much for joining us this evening. Any committee members have any questions? Thank you, Ms. Bonilla.
Thank you.
Next up, we should have Amanda Bruno. Welcome to the committee, Ms. Bruno. You're here to testify on Senate Bill 183.
Oh, yes. Hi. Thank you. This is Amanda. Yes. Did you say hold on?
Yes, you may continue your testimony. Welcome.
Yes. Hi there. Yes, I am here to testify today because I am a landlord in Massachusetts and I am a landlord in Rhode Island. And I've had experiences in Massachusetts that have been very negatively affected me and my family when it came to certain tenants that we've rented to in the past. And one of the reasons why we moved forward with buying and investing in Rhode Island was because we had more freedoms as far as landlords of where we were able to choose our tenants and also just protect our properties that we worked very hard for. And I believe that every person has the right to live where they want to live. But as a landlord, I feel like it should be our right to be able to pick a tenant that meets the criteria that as far as having good credit and having a good background as far as credit, a criminal background and just certain criteria that you want so that you know that they're a person that is going to respect and take care of your property. And so because of the experiences I've had in Massachusetts and know how it negatively affected me and my family, of where actually we had somebody living there that was on a voucher, and it was time for them to move out, and they had done some things that were not good, but they were moving out, and they had caused significant damage to our home, and it was a home that we had worked hard to have, and when we told them that they were not going to get their security deposit back, they threatened me and my family, and basically we were put up against the wall to give them their security deposit back, even though there was significant damage caused to the house. But we were actually threatened. We feared for our safety to the point of where we made that decision. And so I just don't want to be put in those positions again, moving forward as far as a landlord in Rhode Island. And I feel like it is important to just understand that most landlords are really just regular people that have worked really hard to save to have an additional property. We're not these big companies that own lots and lots of properties. And I think that it's important just to be fair to everybody. And that's all I have to say.
Thank you. I also see that you want to testify on Senate Bill 528.
Yeah, and it's basically the same. The same sentiments.
Very good.
The same sentiments that I have.
Thank you. Do any committee members have any questions of Ms. Bruno? Thank you for joining us this evening, and thank you very much for your testimony.
Absolutely, and I really appreciate the call today. Thank you.
You're welcome. Susli? Next on the line will be Susli Murillo. Welcome to the committee.
Hi, yes.
I believe you're here to testify on Senate Bill 183?
Yes, ma'am.
Okay. Go ahead.
My name is Susela Murillo. I'm here to testify on facing eviction. I'm a housing advocate, community leader, and I'm testifying in this bill because me personally, I was part of an eviction second time during the pandemic. It has affected my family. I have landlords who don't want to participate with any programs. And then here I am, lost my job, don't have anywhere else to go. Past evictions on my record won't give me an opportunity to rent a future apartment. So everything that goes in an eviction, it affects you mentally, physically. I got 3 kids. You also got to think about school. You know that you got to switch schools. You got to make it work or whatever, drive more, or it's destroying families. Whenever you have dad and mom having to make any ways to pay rent, and then you have landlords abusing from the power, you have landlords who think that because they're landlords, they can have you living with animals, with infestation, with rats, not being able to be in a comfortable house because you have the fear that you might lose for the next month. You try to pay rent, and then you have your landlord making your life every day miserable because you're allowing him to do this. So in order for this to change, people, to hear all of us' stories. My story personally, I'm undocumented, I'm a Latina, and it is affecting me just like other families. But I'm not scared to speak, and I just wish landlords and tenants would find another way to find our solutions instead of bringing us to court every other year, ruining our records, making our kids' lives miserable, and having to go crazy just to look for an apartment that goes from $1,600 to $1,800 when we only work, when we're low income, and it's really hard right now. But especially, we're not saying we want landlords to be punished, but we're not saying tenants should be punished. We're just saying to make it any means for us to have a good relationship. And if they can get help, we can get help as well. There's help for both of us. We just need to both of us participate. So it does affect in every single way if you put it out there. Again, I'm a housing advocate, and I won't stop speaking on this. And this is just the beginning. We will still support any bill that comes when it comes to housing rights because it's a right, and it's unconstitutional to have families living on the streets when there's so many properties out here who could be rented to people without discrimination of what they work, what they do for a living, or who they are as a person or as a human being.
Thank you.
In God we trust. Thank you.
Yes, and I appreciate your passionate testimony this evening, and we are trying to figure it out.
I know, ma'am. It's really hard, and it's devastating when you try to do every single thing to keep an apartment, and then you have landlords who won't participate in anything at all.
Thank you, Ms. Murillo. Any questions for Ms. Murillo? Thank you again for your testimony.
Wish you the best.
Thank you. We're just waiting for the next witness. Next, we have Brian Bishop on the line. Welcome, Mr. Bishop, to the committee. You're here to testify on Senate Bill 183.
All right, thank you, Senator Coyne. I want to come on the heels of someone who suggests it's important to recall that not all landlords are great guys, because you hear plenty of horror stories about some difficulties with tenants, and that may be fair to say. The real problem that I have with Senate Bill 183 is that not that it's a progressive bill or kind of the way things are going, but actually it violates, in my mind, the sense of how progressive legislation is arrived at. And the quintessential philosophical approach to legislation is to make sure that you use a veil of ignorance, that if you were to be the housing provider or you were to be the renter, but you didn't know which, that you would look at the legislation and you would think, well, it'll be fair regardless of which side of the coin I fall on. And I think looking at this legislation, it's clear that it intends to help people that need housing, but it does so with complete disregard for the housing provider. There's nothing in the bill. I mean, people speak euphemistically in the background, oh, we're going to have some programs and we're going to have that. Look, I mean, realistically, if you want people to provide housing, and in an emergency or at any other time for people, and you say we want to stop processes, we need to protect people who may be unable to pay rent, then you have to provide where the guarantee comes from that the rent will be made up. Otherwise, anything you do, whether it's an eviction moratorium or whether it's adding a mediation process which adds time, simply adds to the potential loss for the landlord. And that is in no way recognized by the bill. It's equally clear that in the kind of process that these bills take, that the senators speak about working with various groups that are concerned about tenants. I mean, that's fine. But what I don't hear is that the senators trying to see these bills pass and who care about these bills to say, I've been in contact with landlords. I sit with the landlords. I understand that this would be a difficult sell for them, but I'm really trying to work and find from them, how we could work as partners. But that is not the way the bills are presented. They're presented as we're working with these justice organizations, and this is what we're going to accomplish. And if something needs to be fixed, it's a question of going back to the justice organization. I say, how about talking with the housing providers, the people that actually provide this?
Mr. Bishop,
and
I appreciate your words and I appreciate your testimony, and that's the whole purpose of the hearing that we're having today, is so that we can hear from everybody who has concerned about any of the bill that is presented tonight or any other night that we have hearings. So your testimony is very valuable in lots of aspects, and we appreciate your passionate testimony. And everybody is listening, so I do appreciate it. Does anyone have any?
Thank you. I didn't imagine you weren't listening. It's just sometimes the process is one where one group gets or has been to the side. So if we come on strong at a hearing like this, it's because we haven't been at the table prior. I thank you very much.
This is the start of the process, and we do appreciate your testimony. Anybody else have any questions of Mr. Bishop? Thank you, Mr. Bishop. Next is, I believe on the line will be Clinton Anani. I don't know if I got that correct. Clinton Anani, welcome to the hearing. I believe you're speaking on Senate Bill 183, and I'm sorry if I got your name wrong. Yes, thank you. Go ahead with your testimony.
Good evening, Madam Chair, and good evening, Senators. I just wanted to bring out a few points in regards to Senate Bill 183 and 528. First, I'm going to start with Bill 183. So when I heard the discussion earlier, there was an assumption that many of the renters would volunteer for rental compensation or coverage protection in regards to not being able to pay rent. As a landlord, I personally have seen many other cases where tenants have not volunteered that information or the information required to get rental compensation. So it's not a given that renters would volunteer that, and the reasoning for that is the following. One, if they feel that the landlords are getting compensated, but they're not getting compensated enough to be able to continue their normal life living, then they have a less incentive to actually cooperate. So I just want that to be kept in mind when we think about that, assuming tenant cooperation.
Okay.
Secondly, renters at times in court do seem to be more accommodated versus owner-occupied landlords, because we're always assuming that our housing providers, that just housing providers of properties that they don't own, that this is a case only for them. This is actually also a case for owner-occupied multifamily landlords. So we just want to be careful when we, kind of talk about this in this discussion. Also, for housing providers, when they don't receive rent, they could go into a foreclosure case. And the main problem, what I see from these bills that they're trying to solve, which is homelessness, actually, potentially landlords could also, given the owner-occupied point, could become themselves homeless. So,
okay.
So one of the things I will do, and I'll go on to Bill 528.
Very good.
And the reason why the discussion with that is the way I look at that bill is landlords should have a right to protect themselves and get information in regards to the people that they're potentially renting to, similar to the way you would when you apply and receive a job. In many cases, when you receive a job, what they'll tell you, or you can call them employment providers, would say, hey, we would love to work with you, but first we have to get a background check. And also, in addition to getting that background check, we have to get references to verify you are who you are so that we feel protected and we can work with you. As a landlord, we would love to work with our tenants.
And
we just also want to feel protected. Yep.
And you are you are representing Rhode Island Coalition of Housing Providers today, is that correct?
Yes, I am representing Housing Coalition Providers.
Thank you.
You're welcome. So I just, in closing, would like to state, lastly, that I personally will volunteer any services I can provide the senators or anybody else into coming to a solution that works for all parties involved. And I know sometimes we always say that we want the bills to be fair, but sometimes we have to really be willing to put the work in. And I'm telling you right now on this call that I'm willing to put in that work.
Well, and I certainly do appreciate that, because getting together all the stakeholders and trying to come to a compromise is very, very important. And so I appreciate your willingness to work and volunteer your time to help out on this bill. Thank you, Mr. Anani. Does anyone have any questions?
Oh, sorry.
This witness?
Go ahead.
I don't
Thank
see.
you, Madam Chair, and thank you, Senators.
Okay. Thank you so much for your testimony tonight.
Thank
you. Next, we have Steve Conti. Welcome, Mr. Conti. You're testifying on Senate Bill 183, I believe.
That is correct, and I'm calling to voice my opinion against the bill. I'm an attorney. My main practice is evictions. I represent mostly mom-and-pop landlords. I own roughly 30 units myself. The problem I'm having with the bill is that start with the diversion mediation portion of it. It just creates another hoop for the landlords to have to jump through. I don't see how the logistics can actually be worked out in district court. If they want to make it easier, they should just hire another civil court judge. When you go through this, it's just going to delay it. They want the mediation. the tenants will not even negotiate most of the time in the mediation in advance because they know if they don't, they would delay it and end up and have to wait till they get to court in order to actually make a deal. So they'll just use it as a delay tactic. As far as the eviction moratorium again, that is so general itself. Again, as they said, it could flood in Warwick at the mall and everybody doesn't have to pay their rent. I want to correct a couple of things from my brothers here and Mr. McMinn and Ms. Wood. First of all, a 9-day letter, a 9-day summons on a non-payment of case hasn't been in court in 9 days in years. Right now, it's roughly 6 to 8 weeks to get into court. As far as the 70,000 cases that are filed in district court, only around 8,000 per year are evictions. They do have court mediators inside the courtrooms to try to work stuff out, but as far as being an attorney and working stuff out, I usually can work it out a lot faster and easier myself. The problem with the money being owed, by adding this or anything that extends the time out, it's basically uncollectible debt. So the problem with the landlord, in pre-pandemic days, a landlord would lose 2 to 3 months rent. During this pandemic, landlords are losing 6 months to a year's worth of debt that they are never going to collect. Yes, some of them have collected under Safe Harbor or United, but most of them are not. As far as the this mediation program is in Connecticut and Massachusetts, yeah, it may be, but it's one of the worst things that could go in Rhode Island. If you speak to any other attorney that works in Mass or Connecticut or any landowner, they'll tell you that the climate is worse and it's harder to get a tenant out in Mass or Connecticut than here. So why do the reverse and make it worse here for the landlords here? The other thing, just quickly on the 528, the sealing of the records, again, the mechanisms, sealing and unsealing, I think the better way to do it, to make it cleaner and simpler, is that you file it, it's a normal eviction. If the tenant wins and the case is not appealed, then it's sealed. One shot, it's over. You don't have to do anything else. All right?
Well, thank you.
That's basically
Thank you for your suggestion.
Thank you.
Do any committee members have any questions of Mr. Conti at this time? Seeing none, thank you, Mr. Conti, for your testimony this evening.
Thank you. Bye.
Next up will be Mr. John Dooley from the Providence Apartment Association. Welcome, Mr. Dooley.
Yes, thank you for letting me testify.
Sure.
I'm also against these bills, and I'm going to try not to touch. I've been watching the live stream and try not to hit all the same points that other people have brought up.
I appreciate that.
But I think you get a sense that landlords, we're not the bad guys. We're not, we're providing. Most of us started out, we bought a place, we lived there, we rented out the other units, we fixed up the building, and then often bought another place around the corner or in the neighborhood, and slowly built up a little bit of a nest egg through a lot of hard work and our own. Money and risk and everything. One of my biggest problems with this bill is that when you say you're going to do a moratorium, and this gets to a little bit of what was just spoken about. If you have a moratorium on you say, well, we'll do it on the foreclosures as well. Well, the problem is at the end of 6 months or when the pandemic's over, if the rent hasn't been paid by somebody, the landlord is not going to be able to. The tenants are probably going to just leave. And I've never heard of anyone ever getting back rent when they have gone through an eviction. And landlords, they don't want to have to evict anyone. It's like cutting off your arm so you don't die of gangrene. It's the last step any landlord would possibly take. And it's really upsetting when I hear people saying that, they want to throw everybody out. They don't. That's the last thing they want to have to do. But they have to do that at some point so that they don't end up getting foreclosed on, and everyone else in their place ends up being homeless as well, because that's what happens when the banks foreclose. They throw out everybody. That's what happened in Providence a number of years ago with the housing crisis. So, let's see if there's anything else. That's basically the main point I want to make. A lot of other people have said similar things I was going to talk about, but thank you for your time. I appreciate it.
I do appreciate the fact that you're keeping it brief for us as we move on to other witnesses. Does anyone have any questions of this witness? Thank you very much for joining us this evening.
Okay, thank you.
Next up will be David Veliz of the Rhode Island Interfaith Coalition to Reduce Poverty. Good evening, Mr. Veliz.
Good evening. Thank you for having me.
I understand that you're testifying on Senate Bill 183 and 421, I believe.
Yes. Thank you very much to the committee and Chairperson. My name is David Veliz. I am the director and lead organizer of the Rhode Island Interfaith Coalition to Reduce Poverty, and I'm here to voice my support for the following bills. First, on 183, thank you to Senator Ewer for introducing it, everyone who signed on. This is about housing security, and housing insecurity is higher than ever before, and the pandemic has made this problem a lot worse. And uncertainty can be traumatic for families, and in a state of America, in emergency, we are just trying to keep our families safe. Many people lost their jobs and income during the pandemic, and it would have been disastrous if the federal government didn't step in. We can't take that for granted. We must make it so that in Rhode Island we are protecting families during a crisis. When people are worrying about food safety bills, we can't have them facing homelessness. This legislation makes so much sense. Why wouldn't we protect people? The Rhode Island Interfaith Coalition to Reduce Poverty represents over 80 faith organizations, local congregations, and service and advocacy organizations across the state. As people of faith, we believe that all individuals and families deserve the right to a decent and safe place to live. We believe that housing should be a right and not a privilege. For Senate Bill 421, this bill is close to my heart. As someone who was undocumented as a child, I remember the fear that existed in my home regarding housing, food, and medical treatment. I always think back and thank God that a local pastor took my family in and rented us an apartment. He saw a hard-working single mom who wanted a better life for her kids, wanting the American dream, wanting to escape a war, and live in a great land. I'm grateful that that landlord didn't see a different narrative, a twisted immigration narrative that we often see in this country. But I'd like to believe that in Rhode Island we are better. We are heading in the right direction. We have a vibrant immigrant community that contributes a lot to the economy and to the culture of the state. Also, this is about housing. There is a lack of affordable housing. So if a person is finding housing, we should not be giving any additional barriers. Speaking about barriers, lastly, I want to show my support for Senate Bill 561. Thank you, Senator Coleman, for introducing one. Rhode Island currently has a shortage of decent affordable housing, as I mentioned, and many families struggle to find housing they can afford. The problem of finding housing can be even more difficult for families who pay part or all of their rent with income from sources other than employment. Many Rhode Islanders already face discrimination based on race, sexual orientation, and even age. We should be doing everything we can to end discrimination and to keep people housed. We don't need any more barriers for families. This is about doing what's right. People should not be automatically assumed to be unacceptable or undesirable tenants simply based on their source of legal income. Every renter should be given an equal opportunity to apply for housing and be evaluated on their merits. During this uncertain time, we have a moral obligation to keep people housed and safe. Thank you all for your time. Thank you all for hearing me. And I'm sorry if I spoke really fast. I always get jarred by the phone calls.
It's okay. Thank you very much, Mr. Veliz. You did a great job. Thank you. Are there any questions for this witness from members of the committee? Hearing none, thank you. We'll go to our next caller, who is Brenda Taylor, on behalf of DARE.
Oh.
Hi, Ms. Taylor.
Yes.
Yes, good evening.
Good evening.
You may proceed.
Say that again?
You may proceed, thanks. You're on for the committee, so go ahead.
I'm calling on behalf of the South Side. I live in an area on near Point and Prairie and Friendship. And I'm calling concerning evictions in our area and what they do during this time of COVID. and how difficult it is for families and people in general to survive. It's very hard. One of the things that happened to me that sent me to a local organization, which was there, I had received an eviction notice, and I couldn't understand why. I had paid my rent, given it to the manager, and left saying everything was okay. About 5 days or so had passed, and I get this note that it's a letter that I'm being evicted on grounds of non-payment of rent. So what happened to me, because I'm a little older, quite a bit, over 60, I had something happen where I couldn't breathe, and I couldn't understand that. My heart was racing. I said, oh, my God, what's happening? But what I found out, it was a panic attack or an anxiety attack. Because this situation was out of control. Where am I going to live? What am I being evicted for? I paid my rent. I'm not a bad tenant. What happened? Well, I'm going to DARE. They checked upon the information. They called the manager's office and, different things, and went on my background and that I'm very good with paying my rent. And come to find out, the young person had put it somewhere and forgotten it. It was a check, and they had forgotten where they had put it, and then they found it something like 12 days later. And I went through a lot. I had to go to the doctor. I had to get a medication, because trying to find housing today, unbelievable. Unbelievable. I said, where am I going to come up with if they're asking something like $600 or $700 or $800 a month for maybe a one-bedroom? I need 2 months of a security deposit. That's $16. I don't have that. I have no way of getting it either. So that was my dilemma there. Now, here I am in a community where I know a lot of people. I've met them, I've spoken to them, and here comes COVID. And people are losing their jobs. People are being told, well, I'm sorry, but you're going to have to go. I got to get somebody in here that can pay rent. But they are not understanding that these people are under really hard hardships. They have families they have to take care of, support. It's a lot. Lights, in the complex where I live, if your lights go off, that is grounds for eviction. Your utilities, if they go out, you got to go. So the housing stock, we don't have that much, and it's not affordable. It's not all affordable. If you have to pay something like $1,200, $1,500, you better be making $30 or $40 an hour to be able to pay $1,200 or $1,500 a month for rent. And we all don't make that kind of money. Professional, maybe the plumber, maybe a welder, I don't know. But we're not making it. And we need, in our area here in South Providence, something called affordable housing. Also during COVID, there are families that are being separated. Or maybe you can go and stay with my cousin. These kids go over here and stay with because you're trying to find this is all dangerous. We need help with housing. And then people that are able, of color, to get a house, and they're under the same situations, maybe losing a job or losing someone that was there to help them pay the bills or the tenants. They're in dire straits. It's tough. It is, and they're going to lose everything that they've tried to work so hard to get.
Mrs. Taylor,
and I know,
Ms. Taylor, thank you very much. I always appreciate your comments. I just ask if you could wrap it up very quickly. We've got 100 people.
Okay, honey, I will.
Yes, I always appreciate you. Thank you.
I'm going to wrap it up real fast. I think the only thing I can say is to love one another and do the nicest thing for each other. The people at the top may be looking down, but there's always that chance of the same one looking down may be looking up also. So COVID showed it to us all. Thank you. Have a good evening and a good day. God bless. Bye.
Thank you very much. Amen. God bless. Are there any questions for Ms. Taylor from the committee, members of the committee? Oh, thank you. Our next caller is Malchus Mills with DARE and the Homeowners Association, Tenant and Homeowners Association.
Hello?
Malchus, are you there?
Yes, I am.
How you doing, my friend? Good to hear from you. Please, you can proceed.
Okay, what I would like to impart to the committee, in fact, hello everyone that knows me, and for those you don't, I hope when we start to meet in person again, you'll get a chance, we'll get a chance to talk. It's very important that we have a continued moratorium on evictions and foreclosures. We're going to strain an already homeless rolls as it is. There's no need in making, new homeless people. I mean, we're supposed to have, or tenants are supposed to be able to go and apply for money so that they can pay their rent and whatnot. Why don't we make that more accessible? Why is that so difficult for folks to get, to that money? You know what I'm saying? That is sorely needed. Excuse me. Plus, that would help the landlords out also. I mean, we cannot, let this virus turn, landlords loose just to put people out, to be putting folks out. You know what I'm saying? I mean, it just can't happen. It's not going to be a pretty sight, for real. There has to be another way. It has to be a better way, to continue the Fed moratorium would be the thing to do, because people, even after the pandemic is over, people are still going to need a few months to get it together, because, they'll be just going back to work, and, you can't pay everybody all at once, unless they're going to suspend all of that and just help the landlords out, with their mortgages, and still keep the tenants there until they're able to pay. This bill, it makes sense, because, it's going to help people stay in their home. It's going to help families stay in their homes. And this is what's needed, we're just, okay, winter is flowing by pretty quick, and we still can't afford to be putting people outside. We just cannot. We have to continue the moratorium. We have to find a way to get money into the tenants' hands that need it, to the landlords that need it, and that has to come about. That has to come about, because the black and brown and the poor communities are feeling the brunt of this, and we need your help, and we need your understanding. So I'm hoping that you find it in your heart, to help some of us less fortunate, so that we all can have a home or a place to call home. Thank you very much, and I hope to see you guys very soon.
Thank you, Malchus. Always appreciate your testimony. Do any members of the committee have questions for Mr. Mills? Hearing none, thank you. Our next caller is Kristen Seary, and she is a self-caller. Good evening, Ms. Seary.
Yes, sir.
Yes, thank you. You're here to testify on Bills 183, and I've also noticed 524. So you may proceed. And why don't you start with 183, and then you can move on to 524.
Yes, sir. I actually combined my testimony for both. It was actually 528 and 183. I apologize if I signed up incorrectly.
Okay. That's okay. Thank you. Go ahead, please.
Yes. Okay. Thank you, Chair and members of the committee. My name is Kristen Seary, and I appreciate the opportunity to testify in support of Senate Bills 528 and 183. I am a renter who was evicted in August of 2020 due to alleged non-payment. I'd like to start with a couple sentences describing the situation leading to my eviction and why the particulars are relevant. Then I'll move on to the effects of the eviction has had on my life before concluding with a plea that you please support Senate Bills 528 and 183. In February, just after the start of the quarantine, I was just $65 short on rent. Once my unemployment claim was processed, I tried to pay the little back rent I owed, but my landlord would not accept my money or subsequent payments. I held on to the money, and at my eviction hearing, I presented a payment plan that would have me completely caught up on back rent within 2 weeks. My plan was rejected, and I was given a month to vacate my home. Why is this relevant? I think it shows that this debate is not solely or even primarily about a landlord's right to be compensated. It demonstrates that often these non-payment evictions are not about money. Rather, money is being used as an excuse to evict inconvenient tenants who ask that their units be safe and habitable, for example. This is just one of too many loopholes in the federal moratorium. Eviction at any time is traumatic. At this time, it causes damage to tenants' personal and professional lives that can be irreparable. I'll now move on to the effects of my eviction on my life. Not only did I lose my home to eviction, but I also lost my network of neighbors and friends. I am now without my social support system. I lost my home-based business. My local clientele moved on, and so I don't have a job to come back to when the COVID crisis is over. I had to leave Rhode Island to find affordable Airbnbs, and I don't anticipate being able to return to Rhode Island anytime soon, not with an eviction on my record and an uncertain employment future. I lost access to my Rhode Island-based health care and have had to stop taking regular medications I've been on for years. My health has suffered considerably. But worst of all, my dog Kayla fell ill, and I wasn't in Rhode Island to get her to the vet. She took her last breaths as I laid beside her on the floor of an unfurnished Airbnb on January 29th. All of these losses have made it very difficult to recover and resume my position as a contributing member of society. I think we all, landlords and tenants alike, would agree that the more people that are working and functioning normally, the better for the financial and moral recovery from this global disaster. Protecting tenants from these losses is in everyone's best interest. I conclude by asking that you please support both Bills 528 and 183. 2020 has brought the world some loss that is unavoidable, but there is so much loss and suffering that is preventable. Please protect Rhode Island renters. Thank you for your time.
Yes, and thank you very much for sharing your situation and the sadness of it, and our prayers are with you on your loss. I'm really, really sorry for that. Any members of the committee have any questions? No, thank you very much. Our next caller is Christopher Belotti. Good evening, Mr. Belotti.
Yes.
Yes, thank you very much. You may proceed. You're here to testify on 183, so you may proceed.
I am. Thank you. I just wanted to, I've been a landlord for almost 20 years in Rhode Island, and I just wanted to respond to a couple of comments that some that I've heard that I think were just, based on, misinformation. First of all, I think the eviction moratorium, it actually denies landlords the access to federal funds by stopping the eviction process. Tenants need to be in eviction in order to be eligible to apply for those funds. We've actually had experiences where tenants have come to us that we've been working with and asked us to file for eviction simply so that they could apply for those funds. Some people have said that the landlords are not accepting the federal funds. We, as a policy, my company does, of course, but the biggest reason why some landlords don't, is that it comes with a string attached where you cannot evict for 90 days after you've received those funds. And, to lose 3 months of rent plus, another month and a half or 2 months, during the eviction process is more than a landlord can really bear. And I think if you eliminate that restriction, more landlords will take the money, which is, I think, the goal, because it helps the landlord and it helps the tenant. Let me see. I'm trying to be quick here. The mediation process, the biggest problem I have with the mediation process is, number one, there's already mediation available in court. And so it seems like the only thing it would achieve is to slow the process down, particularly since at least 50% of the tenants who were evicted fail to appear in court. So for the most part, the eviction process is just a clock that's running, and the tenant knows that, when the clock runs out, they're going to move out, and they just stay and for free. So dragging it out another 30 days really just accomplishes nothing. The landlords call, multiple times. I know we do, before the eviction is filed. We call after the eviction is filed. We, if a tenant appears in court, we always try to make some kind of a payment plan with the tenant, if they're obviously amenable, and if they appear. So the mediation, slowing the process down by adding a mediation process, I think, is counterproductive. And the other thing to keep in mind is that anytime you drive up the cost of eviction, you force a landlord to tighten his credit standards, which only squeezes more tenants out of available housing. And so it actually does exactly the opposite of what you're trying to do. And I think there's a lot of things that you could do. And I would love to, have the opportunity to talk to, either my senator, who I think is Senator Archambault, or, any of the senators who are interested in talking about ways to increase access for tenants to more housing and better housing.
Mr. Belotti, I appreciate your comments very much. You're actually my constituent then, and you can feel free to call me after tonight, and we'll talk at length on any bill you want. I really do appreciate your comments. I do have to move you along, though. We've got a lot of people ahead of us, and
okay.
Can you wrap it up? Are you all set, or?
One thing I would say is just really quick on the sources of income bill. I do support that, and we do not discriminate on source of income, even though I wasn't even aware we had the right to discriminate, but we don't. But most of the Section 8 tenants that aren't able to rent from us are not able to rent from us because Section 8 doesn't pay a high enough rent, and we can get more in the market. And so I think re-examining the market rents that Section 8 pays would be better for the landlord and the tenant.
I appreciate that very much. Thank you. Are there any questions for Mr. Belotti from any members of the committee? No. Thank you very much for your testimony, Mr. Belotti.
Thank you. Yep.
Our next caller is Kate Shapira. Ms. Shapira?
Yes, I'm here.
Yes, good evening. Thank you. You may proceed. You're here to testify on 183, so you may proceed.
That's correct. Thank you to the chair and the vice chair and to the committee. Senators, the merits to all of your constituents of passing this bill are that people get to stay in their homes and retain their property. Senator Oyer laid it out really well, so you already know that it makes sense for people to stay in their homes during a health crisis, which is also during a housing crisis, which is also during an employment crisis. It makes sense because losing homes to eviction or taking yet another big financial hit through foreclosure would compound the damage from all of those things and make them harder to come back from, trapping people in poverty, exposing them to COVID, and straining their relationships in the ways that many witnesses have already spoken about. And now I want to talk briefly about the merits to you. This bill is easy. It is so easy. with the exception of the mediation process that it provides for, which does involve doing a few things in a simpler and less punitive way. It is mainly about doing nothing and committing others to doing nothing. Most of the things that would actually help Rhode Islanders with housing require a lot of people to do a lot, spending money, restructuring a business model, building units of housing, and so on. And I believe some of those bills are going to be coming across your desk as well. But this mainly requires you to just say no. And the no that you have to say is not even going to hurt any of your constituents. If you own rental property, it's also going to hurt you. If this bill only covered tenants, I can understand being a little wary of it. Your constituents or yourself, if you own and rent property, could potentially be hurt by it or worry. And you've heard some of them express that fear tonight. But the moratorium does cover foreclosures as well. Senator Rogers, I also heard you raise this concern. So the main entities that could potentially be hurt by it are banks. And of everybody in this chain, tenants, landlords, property management companies, and banks, the banks are by far the best equipped to absorb the shock. They are literally where the money is. They are set up to ride waves that will swamp many landlords and almost all tenants. And the banks are not your constituents. Other than possibly your own mortgage payments, you don't owe anything to banks, whereas to your constituents, you owe the representation of their will. And I guarantee you, and you've heard some tonight, that part of their will is to choose when they move and to not have their lives further disrupted. The other merit that this bill is going to have for you is that if you pass it to the Senate floor and vote for it there, your names will not be publicly linked, including by me, as loudly as possible, to a truly incomprehensible failure to provide some basic security for Rhode Island residents and give our state a chance to rally both this time and in the next emergency. I heard a couple people on this committee describing this legislation as well-intended or altruistic. That is not what this is. It is making sure that the people who keep this state running, the people who this bill would do the most for, are the people who have been described as essential workers throughout this pandemic but have not been treated as essential by the state. It is making sure that those people will not be too cold, too hungry, too destabilized, or too sick to do that work. Senate Bill 183 builds in breathing space that Rhode Island owes its residents for keeping this state running during this time. It builds in resilience that serves us all. Please expedite whatever further study is necessary to bring it to the Senate floor in time to serve people who need that breathing space and that resilience now. Thank you.
Thank you, Ms. Shapiro. Are there any questions from members of the committee? Hearing none, thank you. Our next caller is Jacqueline Goldman. Good evening, Ms. Goldman.
Hello.
Hi, good evening.
So I'm here to testify. My name is Jacqueline Goldman, and I'm here to testify on 183, 561, and 421, but also I would like to add support for 131, 528, and 563. So as I said, my name is Jacqueline Goldman, and I work in public health research, primarily with folks who are unstably and marginally housed. One of the things that we're already seeing is that there are new tent villages popping up all the time. The rate of people who are unhoused and unsheltered in Rhode Island is up 500% from last year. And this, we all know all of the consequences that come from being unhoused. We've heard very passionate and very important arguments from tonight from people who have been evicted and all of the things that that's caused them. And if we care about the people in our state, one of the things that we need to do is to protect people from becoming homeless in the future. Already, our state does not have the infrastructure to be able to support people who are unhoused, and it costs more money to rehouse people than it does to keep them in their current apartments. And this means that we need to make sure that these people are not evicted and forcibly removed from their houses. Now, I hear the small landlords and the concerns that they have, and I know that in the House version of this bill, there's actually a fund to be able to protect small-time landlords. I also think that we need to listen to the testimony that Kate Shapiro just gave and talking about the fact that this really impacts the banks and that they're the ones who can bear the shock. And so I urge you to pass all of these different bills that break down barriers to housing. This means ending discrimination on income. This means ending discrimination based on gender, sexuality, immigration status, and things like that. And also making sure that when someone dies, the other people living in that property have access to housing. So I urge you to pass all of these on behalf of tenants, on behalf of your constituents, on behalf of the people of Rhode Island. Thank you so much.
Thank you very much, Ms. Coleman. Are there any questions for this witness from any members of the committee? Hearing none, thank you. Our next witness is Attorney Patrick Gamelin. Mr. Gamelin?
Yes, thank you.
Yes, good evening. You may proceed.
Good evening. Thank you. To the esteemed members of this committee, by way of introduction, my name is Pat Gamblin. I'm a member of the Rhode Island Bar, as well as the Bar of Massachusetts. I've been a practicing attorney for over 15 years, and I worked as a partner for the Flynn Law Group, which is one of the largest landlord-tenant firms in New England, as we have clients in all 6 New England states and offices in 4 of those states, including one in Cranston. On behalf of our clients, as well as IREM Greater Rhode Island Chapter 88, which we're an industry partner of, we strongly oppose the proposed legislation contained in Senate Bill 183. In particular, as an attorney, I wanted to use this opportunity to speak to you about the clear unconstitutionality of the moratorium section of this bill. It's first important to point out that this proposed legislation would effectively severely limit or completely shut down housing providers' access to courts for an unknown, unspecified time. It would allow for the state to do so again in the future. The state of Rhode Island has made it through the War of 1812, the Civil War, the Spanish flu, the Great Depression, 2 world wars, and multiple recessions. And throughout all of it, it's never imposed a wholesale moratorium on the most basic right of a housing provider, which is the right to file a case and potentially evict a tenant. There's 4 specific areas of the Constitution that I want to draw your attention to if passed, this bill would certainly violate those rights of housing providers statewide. And I've parsed this down just in the interest of time, and I'd be more than happy to take questions on any of these sections, but the 4 are the First Amendment right to petition the court, the First Amendment right to free speech, the right to just compensation for an unlawful taking of property under the Fifth Amendment, and the right to not have lease agreements unconstitutionally impaired under the Contracts Clause. What may be the most damaging to both housing providers and tenants alike is the federal funds that have been spoken about a few times tonight as part of this testimony. They have thankfully started to be released, and but the thing is, they have many stipulations on them. From the research I've done and what I've seen, these funds are earmarked for tenants facing eviction who have either been served a demand notice or have been taken to court. And the time frame on using these funds is limited. The legislation that's been proposed does not allow either of those to take place, either sending a demand notice or filing a case in court, which means that at the end of the moratorium, the money will likely no longer be there, and tenants will still owe thousands of dollars with no way for them to obtain relief, causing a virtual tsunami of evictions. No one is going to dispute that the last year has been tough on just about everyone. Housing providers in the state were effectively subject to a moratorium until basically July of 2020, while courts were closed. It's likely that not all were happy with the decision, but they seemingly understood its purpose. We were dealing with a virus that we knew virtually nothing out. Hospitals were full. We were subject to mandatory shutdowns and closures, as well as stay-at-home orders.
Mr. Gamblin,
but it's almost a year later to the day, and the road to...
Mr. Gamblin, if I may, we're going to have to move it along. I've given you a little over, but we have a lot of testimony tonight ahead of us. So if you could wrap it up, please.
Sure thing. I'll just say this. Massachusetts, for instance, did literally the exact same moratorium back in April of 2020. It was challenged in court, and after the judge's decision, the governor of the state of Massachusetts decided not to extend the moratorium further, thus ending it in October of 2020. The judge who heard that case is Judge Mark Wolf. He's been on the bench since 1985 and is former chief judge of the U.S. District Court. His opinion on that moratorium is very important and I think needs to be pointed out. Judge Wolf reasoned that, quote, the COVID-19 pandemic is not a blank check for the governor and other elected officials. Rather, it should be recognized that a public health emergency does not give governors and other public officials carte blanche to disregard the Constitution for as long as the medical problem exists. I thank you for your time, and I hope you'll do the right thing and the legal thing and not advance this legislation.
Thank you, Mr. Gamlin. Are there any questions for this witness from any members of the committee? Oh, thank you very much. Our next witness is Tal Frieden with Reclaim Rhode Island. Good evening.
Hi.
Hi, you may proceed, thank you.
Hi, my name is Tal Frieden, and I am a member of Reclaim Rhode Island, and I work for Demand Progress. And I'd like to testify in favor of Senate Bill 183 and the bills preventing evictions and foreclosures for the duration of the pandemic. And I want to start by saying that these eviction and foreclosure moratoriums for the duration of the pandemic are a compromise. These bills state that no tenant should be kicked out during a pandemic and no homeowner should be foreclosed upon in the middle of a public health emergency. But these bills don't guarantee housing as a human right or provide homes for all or end the cycle of poverty and houselessness that plague our state. It just makes sure that the most vulnerable people aren't forced into the street in the middle of a deadly pandemic. And I want to briefly share a story about a friend of mine who left the ACI, the prison in Rhode Island, just over a year and a half ago, who has experienced housing insecurity since they re-entered society due to addiction and the lack of services for people experiencing addiction, the high barriers to re-entry after years of incarceration, and the unaffordability of the housing market in Rhode Island. Since they were released from the ACI, they've moved between sober living houses, friends' couches, occasionally being able to hold down an apartment, but consistently facing housing insecurity. And I've watched as this person has struggled to find their footing after being in prison for years. And the reason I mention this story is the bills in front of us tonight, Senate Bill 183 and the bills preventing evictions during the pandemic, really ask the question not of whether everyone deserves housing, which we know is morally true, but rather who should bear the burden of the failure of our state to provide housing as a human right. We are watching as this failure plays out across the country, and especially in Rhode Island, where a living wage is over $23 an hour. These bills ask us who should bear the burden of this failure of our state to provide housing. Banks provide mortgages knowing the risks of a housing market, and if they lose money on their investments, no one loses their home. Senate Bill 183 protects the most vulnerable during a public health emergency and is an important stopgap measure to make sure that tenants and homeowners don't get kicked out of their homes in the middle of a public health emergency. This means that the only people who may lose out at the end of all this are large banks who accepted the risks of providing mortgages and who may not make as much money on loans that they doled out knowing their own risks. As I said before, these bills are simply a compromise. They don't provide housing as a human right, which should be the goal of housing policy in our state, and instead just ensure that the people paying the price of our failure to provide housing are not tenants or homeowners, but rather banks that can afford to take losses during a public health emergency to make sure that people can stay in their homes. Thank you.
Thank you very much. Are there any questions for this witness from any members of the committee? No, thank you very much. Our next witness is Ruth Diamond Madsen with the Rhode Island Coalition for the Homeless. That is the Voices of the Homeless. Ms. Madsen?
Yes, sir.
Yes, good evening. I see you're here to testify on several bills, 183, 528, and 561. Is that correct?
Yes, sir. It is.
Oh, yeah. So you may proceed, and why don't you just address all the bills in your own turn?
Okay. Kind of off tonight, so you got to forgive me. I want to first start off by telling you guys thank you for listening to us as constituents and people that are calling in. These bills, to me, are very important, more so now in those last 24 hours than anything. I was originally homeless, and I've changed my life dramatically. I'm now housed. I live in Pawtucket. I'm an outreach worker. I'm an advocate worker. The bills that are up for people are very important, you know. If you have a sealed record for one mistake, you know, that deems you from ever trying to get housing, public housing again. For the income on top of that, I have Section 8. I'm blessed to have my Section 8 voucher, you know, because I can't work, you know, and I'm sorry, sir.
It's okay. You're doing a good job. Take your time.
These bills, you know, they mean everything to me right now. You know, Christina and everybody knows that's with me. This is going to be my last speaking engagement for a little while. You know, I want to tell you guys at State House, thank you for listening. Thank you for being a part of everything. You know, I'm going to carry you guys with me in my heart. I just lost my brother Tuesday, you know, and my brother was a police officer in Tampa. He got killed. He was an officer that got killed on the wrong way driving. And what I do now, I'm realizing that it makes a difference in people's lives, and that's what he was here for, to help people when they needed it, good, bad, or indifference. And, you know, I speak because I want to help people. I speak because people that were in my situation can't speak because we get punished, even down to me right now with what I'm going through with my housing issues, and I'm housed. I'm being punished for something that, you know, doesn't make sense. Discrimination is everywhere. Nobody needs to be discriminated because of race, creed, color, gender, income barrier they have. You know, we're all the same. You know, if we just put our arms together, you know, we bleed red the same. Our skin color is different, but everybody's here to help everybody. At least they're supposed to be. You know, and I'm going to carry that message from now on more because, you know, my brother retired after, he got killed after, and it was his final watch Tuesday. It was 17 years before he was a police officer. He also retired as a Simplify from the U.S. Marines. You know, my family does a lot for people like me that were where they're at, and I'm going to continue this because my words are powerful. I'm here to help people. You know, the State House, I commend you guys so much for giving me a chance to speak on these bills, to learn how to come into the State House and talk to you guys, because it's not something I'm used to. But please, if you take anything from what I say, just consider that you were in our shoes and you didn't have money, or you had a eviction on your record and you need to get an apartment and you had a family and you were sleeping in a car and you couldn't get that. And you had nobody to help you. Think about how these people feel right now with nobody except for you to lean on. To say, please, take this discrimination thing off. Please, take this income barrier off for us. Give us a chance, because they're not all bad people out there. If you sit down and talk to them, you would really be surprised. They're very smart people. They just have bad situations. And everybody has them. But everybody needs a chance to have somebody good in their life. Thank you.
Ms. Madsen, thank you very much for your testimony, and we're really sorry on behalf of the Senate. I want to extend my condolences. We're really sorry for the loss of your brother. That's tragic. So our prayers are with you and his family, and you had very compelling testimony. Thank you for taking the time tonight, even in light of your recent loss. So are there any...
No.
Oh, yes.
Thank you. Thank you for letting me do this, because I love to speak, you know.
Oh, of course. This is your house. So are there any questions for Ms. Madsen from any members of the committee? Thank you very much. God bless you. Our next witness is Wendy Thomas, also with the Rhode Island Coalition for the Homeless and the Voices of the Homeless. Ms. Thomas?
Yes.
Oh, yes, Mr. Thomas. I had Wendy Thomas. Yes, you may proceed. Go ahead.
Yes. I'm Wendy Thomas. I'm part of the Voices of the Homeless through the Coalition for the Homeless. I'm here to speak on 528 and 561 for the most part. F-183, I think mostly I don't know all that much about it at this point, but I think at this point that sounds like they're really asking for time for people to get themselves together so that they can take care of what they have to take care of.
Sure, and you can testify on 528 and 561. You go ahead. That's fine.
As far as S528 goes, seal and eviction records, I don't believe that any eviction records should be showing at all to a landlord until there is a verdict. If there is a verdict against the tenant, yes. Not if the verdict is for the tenant or before it even goes to trial. And on 561, which is, of course, my favorite one, there's no reason for discrimination no matter what. Whether your color, your sexual orientation, your source of income. Your source of income, just because you're getting Social Security, you got Section 8, or in my daughter's case, you're on unemployment, especially in these times, there is no way that you should be discriminated on any of those things, and you should be able to be considered. And I'm not saying landlords have to change their rent to do a Section 8 voucher. I'm saying you should be able to continue to be considered at least on your merits, not on your source of income. Thank you.
Thank you so much, Ms. Thomas. Does anyone have any questions of Ms. Thomas? Thank you again for your testimony.
Thank you.
Next, we have Thomas Waters to testify on Bill S-183. Good evening, Mr. Waters. You may proceed.
Okay.
You may begin your testimony.
Actually, I was evicted unlawfully. I was getting arrested. I went to jail. I got out when all my stuff was gone. And they stole my car, my dogs. I mean, a slum landlord. And I just think it's wrong. I don't understand how people could do that. I don't know. But it's like, it's been now like over a year and a half. It's nuts. I don't think they should have the right to do that. They don't want to fix nothing in the house. We'll collect your rent, collect the rent. They don't want to fix nothing. I don't know. I just want to help people out there. I don't know what to say. That's all I have to say, honey.
Well, Mr. Waters, we appreciate you taking time to give your testimony and speak this evening on this bill. Does anyone have any questions for Mr. Waters? Thank you, Mr. Waters.
Thank you, honey. Let's have a good night.
You
good
too.
Luck. God
you
bless.
too. We should have Terry Wright from DARE, Direct Action for Rights and Equality, on the phone right now to testify. Good evening.
Good evening. Yes, thank you, everyone. I just want to start by saying I am representing DARE, Direct Action for Rights and Equality, where we advocate for families facing evictions and foreclosures. And we also advocate for housing justice. The current bill 183 needs to be, we need this bill to be passed. And I would just really start with a story of landlord intimidation. I have tenant who's experiencing landlord intimidation. And the only reason she is staying at that residence is because she has evictions. And she's afraid of getting evicted and not having a place to stay. I do not think an eviction record should follow a tenant around like it's a criminal record. I just really don't. A lot of court cases, when a landlord's looking at it and they see that it's an eviction, some evictions are ill-gotten. A lot of the evictions are not, the fault of tenants, but they're there, and evictions serve as a barrier for any housing. It's hard to get housing if you have evictions. So I just really think that this bill should be passed, and I'm just asking that this bill be passed at the same time.
I also have you down, Ms. Wright, to speak on Senate Bill 528.
Yes, Senate Bill 528. I'll begin by saying this housing crisis is the result of decades of neglect. We cannot begin to fix Rhode Island's housing crisis without the passage of this bill. And homelessness should not be viewed as normal. Housing is an essential item. I'm afraid if this bill does not get passed that the result would be mass evictions, mass incarcerations. Crime will go up because people will do what they need to do to survive. Mental illness, homelessness, displacement. We are in a pandemic, and I believe at the state and local level, Rhode Island should be taken care of and secured. There should be no evictions happening during the pandemic. That's just, that's my belief. We are here to stop evictions and save lives, and we're going to end up with a public health crisis if evictions are allowed during the pandemic and foreclosures.
Thank you, Ms. Wright. Does any committee members have any question of Ms. Wright? Ms. Wright, thank you so much for calling in, and thank you for your testimony.
Thank you for having me. And stay safe, wear your mask, social distance, wash your hands. Have a great night.
Thank you, Ms. Wright.
You're welcome. Bye-bye.
Next up, we should have Christina Contreras-Fox from the Rhode Island Coalition for the Homeless. Welcome, Ms. Fox.
Hello. Good evening, Chairwoman Coyne and members of the Senate Judiciary Committee. My name is Christina Contreras-Fox, and I'm the Senior Policy Analyst with the Rhode Island Coalition for the Homeless. And we are signed up to testify in support for quite a few of the bills that are being heard right now. But I would like to speak specifically to Senate Bill 183, 561, and 528.
Very good.
So we are very supportive of these bills, and I'm going to take the two bills that deal with evictions first, because eviction is a root cause of homelessness, and this was a crisis in our state even before the pandemic hit. Rhode Island has literally the highest eviction rate in the region. Excuse me, it is even higher than our national average. And this is, eviction being a cause of homelessness is something that is not going to be fixed by a single bill, but we need to see serious action taken in order for this to be addressed, because now evictions during a public health crisis of this magnitude have already been devastating for so many communities and so many people who have already spoken tonight, but it would be devastating for the state overall. Excuse me. And we know that this, the bill that has been introduced would establish a moratorium on both eviction and foreclosure, because this is, even this piece of addressing how do we keep people safe and in their homes during this time, it is a manifold puzzle. We need to ensure that people can stay safe in their homes. We need to ensure that there is money that can be going to ensure that people don't people can pay mortgages and don't lose their property. As some folks have mentioned already tonight, Rhode Island has seen, as a result of several stimulus packages, millions of dollars come in for emergency rental assistance, and this is fantastic and very important. But one thing that's important to know about ERA is that these funds are not accessible to people experiencing homelessness. You have to be on the brink of, you have to be facing an eviction. But if you are evicted and you lose your home, there is really nothing available for you through these funds, even though the money amount is very high. Excuse me. Advocates understand this. The Rhode Island Coalition for the Homeless, we're a dynamic coalition of housing providers, service providers, which I will say are distinctly different from property managers, aka landlords, and others who work together to advance creative solutions to end and prevent homelessness in Rhode Island. We've been very active at the federal level in pushing for there to be resources coming into our state to address our eviction crisis, to address homelessness, to keep people safely housed. But one thing that did not pass in the American Rescue Plan Act was an extension of the moratorium, which is set to expire at the end of the month. And we did not see, as I said, in ERA, an expansion of making those funds accessible to people experiencing homelessness. We need the state to take action here. We need the partnership of the General Assembly. And 528 also is an important step forward in addressing eviction as a root cause of homelessness. As the law stands right now, if a tenant has been taken to court and they are found, the verdict shows in their favor, that eviction still causes them harm. That eviction is still a mark on their record that can't be undone as the law stands right now. And that, we believe, the Coalition for the Homeless and many who have spoken tonight believe that if a tenant goes through the stress and uncertainty and the trauma of an eviction with the verdict decided in their favor, that eviction case should not cause them nor their family further harm. It should not cause them to become further unstable and insecure with their housing or even experience homelessness. This is a very simple step forward that the General Assembly can take that we urge you to. And then to speak to 569, which is ban discrimination based on source of income. This is one that we've come to you before many years, Senate committee, asking for your support here, and you've given that. We're asking for you to do this again. Source of income discrimination is a poisonous concept. Prospective tenants have income. They have a means to pay, but the landlord gets to say right now, I don't like the way that you're paying. This creates a barrier to housing that no amount of self-advocacy or any other recourse can overcome. And I want to share with you the story from one of our call center agents. We help manage the state's coordinated entry system hotline. And I'll tell the story now. I had a client who initially sought diversion assistance.
Ms.
I'm sorry, yes?
Yes, if you could please be brief. We have many people waiting to speak, and we have a 3-minute time limit.
Absolutely. I apologize, but this story here demonstrates this person called us seeking help, and we tried to work with him, but every single time this person went to try to rent an apartment, it did not matter what rapport they had built with the landlord liked them, but as soon as they found out, you're paying with a voucher, suddenly this apartment is not available anymore. SOI discrimination puts the wrong roof over people's heads. We need to remove it. And the other two bills, which deal with fair housing, expanding protections for people based on immigration status and sexual orientation, are also essential. These are all very important bills. We urge the committee to pass that onto the floor because they will help end and prevent homelessness in Rhode Island. I apologize for being wordy, but this is a very important issue, and I thank you very much for your consideration.
And thank you very much. I appreciate your testimony today. Yes, Senator Reptakis.
I just want to bring some facts together. I know some of the witnesses are coming up with some of these facts, but Providence, Rhode Island, out of 100 cities, ranked 75th, 3.8% as far as eviction. So I don't know where the facts are being brought to us that Providence, Rhode Island has one of the highest eviction rates. Rhode Island is toward the bottom. Of the top 100 cities, we ranked 75th. And that's a survey that was done a couple of years ago. So I just want to make sure that any witness that is testifying that the facts are, what they're saying are factual. So we want to make sure that any testimony is given that we're absolutely being factual on the evidence. Thank you.
Thank you, Senator. Next up, we have Fatima Rodriguez.
Yeah.
Welcome to the committee.
Hi.
Hi, Ms. Rodriguez. You're calling on Senate Bill 138, I believe. I'm sorry, 183. Oh, yes, 183, I'm sorry.
That's okay. And I apologize. This is the very first time I've ever done anything like this. So I don't know the procedure. I don't know if I should state my name.
Yes, we have it as Fatima Rodriguez, and you're speaking on Senate Bill 183. If you could keep your remarks to 3 minutes, we'd appreciate it.
Okay, I'm calling opposing it. I'm calling to have it reconsidered by the legislature and to have oh gosh, I'm so nervous. I'm sorry. I have
That's okay. Take your time.
I have a tenant. I'm in a situation right now that I have been stuck because of this moratorium that's been imposed on landlords and not being able to evict tenants. Now, I know that the moratorium is probably set in place to help tenants against, terrible landlords. I understand there are terrible landlords out there, but the moratorium is not helping those good tenants. They're helping the tenants that are looking for an excuse not to pay rent, and that's basically the situation that I'm in. But because of the moratorium, I cannot get my tenant out. Okay, he hears only they can't evict me even if I don't pay my rent. They don't pay rent. That's it. I haven't had a dime of rent since last June. I pay for this guy's utilities. He abuses the utilities. His bills are double the first and second floor in my triple decker, and he does this on purpose because he knows there's nothing I can do about it. I've finally been able to take him to court in January to get an order of eviction against him. I'm at the point where I'm by the time, if I can get him out, if it doesn't get extended at the end of March, I'm out $12,000 of rent and utilities because of this one person that's just taking full advantage of this moratorium. And then to hear that this bill is even being thought to be passed, it's just not right, and it's not fair against good landlords that try to help their tenants. I mean, the good tenants, they will talk to their landlords and they will say, "Look, I'm having a little bit of a hard time. Can we come up with an agreement? Can we this? Can we that?" And usually, as I have done many times in the past, I've owned this house for over 20 years. I try to help them along and have forgiven much rent. In fact, in January, when I took this guy to court, I forgave all the back rent. I just wanted him to move out because I couldn't have him there anymore.
Well,
and it got extended, and it's extended, and the first thing he says to me is, "Well, it's extended, so I get another month."
Ms. Rodriguez, it's important to hear testimony like yours, as well as many others who came forward tonight, and we really appreciate you taking the time. And I know it was a little nerve-wracking, and it's your first time, but we hope that you will return to testify on other bills as well. Does any senator have any questions of Ms. Rodriguez? Thank you very much for your testimony this evening.
Thank you for letting me speak. I appreciate it.
Next up is Alexandra Garay from Project Weber Renew. Welcome to the committee.
Hello.
Hello. I believe you're speaking on Senate Bill number 183. If you could keep your remarks to 3 minutes, we'd appreciate it. Thank you.
You got it. Thank you.
You may begin. Are you still with?
Hello. Hi. My name is Alexandra Garay.
Yes. Begin your testimony, please, on Senate Bill 183.
Thank you. I'm here in support of Senate Bill 183 and also 528. I'm an outreach worker in Providence. I work with folks that are homeless every day. If stopping evictions does save lives, I want to reiterate that anything to keep our people housed and off the streets is harm reduction. I want to specifically advocate for one of my clients who just got wrongfully evicted. They have been in recovery for many years, have been meeting their rent on time without a delay. However, they got wrongfully evicted by having the landlord mistake their name for somebody else. They came home to all of their belongings gone in the trash. Even when evictions happen, they're supposed to hold people's belongings. To this day, my friend has lost everything that they owned, all of their heirlooms, all the family heirlooms, and any pictures left from their family. At this point, this is completely unacceptable. This shouldn't happen to anyone else. During an eviction moratorium, I know that I just heard somebody say that, where are people getting these facts? I would trust the community members that are out there doing the work every day. That's where the facts are coming from, is that maybe you don't see those on those numbers, but these real lived experiences are happening every day, and we must do anything that we can to stop evictions from happening.
Thank you very much, Ms. Garay. Do any of the committee members have any questions for this witness? Thank you for taking time to call in this evening.
Thank you.
Next up, we have Mr. Everett Pope from the George Wiley Center. Good evening, Mr. Pope. You may begin your testimony.
My testimony will be relatively brief. I think it's important for this bill to go through because essentially during the time of the pandemic, there's been so much turmoil, and I just feel as though you should provide protection for both homeowners and both the renters. And from what I understand, this bill kind of provides a safe haven for both the homeowners and for both the homeowners and the people who are renting, and it kind of gives everybody a fair and level playing ground. And also, it's a way where people who don't have the advantage can kind of get a little bit of leverage in a sense. I also think it's just very important that in a general sense that we just have a little bit of humanity return to our policies, and we kind of throw caution to the wind when in terms of when we're faced with crisis and states of emergency. We should always think about putting the people first. So that's my piece. Thank you guys for the time.
Thank you very much for your testimony this evening. Any questions from committee members? Okay, thank you so much, Mr. Pope. Next is Tracy Tuttle. Good evening, Ms. Tuttle. You're here to speak on Senate Bill 183.
Yes, I'm actually, I was actually evicted from my apartment this week. I'm actually staying in a hotel with 7 children. I lived in the premises for 5 years. I was told by the judge that I couldn't, that I had to be evicted because it wasn't for non-payment. So I got evicted for not a non-payment. It was just she had a personal vendetta against me, the new owner. I'm totally against this eviction during this COVID thing. Like I said, I'm now staying in a hotel paying $500 a week, my whole paycheck, to live. I'm not understanding how these landlords are being able to just kick us out like this. I was given exactly 6 days to get out.
I'm very sorry to hear that, but I do appreciate you taking the time in to call and have you express your concerns. Thank you for calling in this evening. Does anyone have any questions? All set. Thank you. Okay. Next on the phone, we have Miss Carol O'Donnell. Welcome, welcome, Miss O'Donnell. You may begin your testimony on Senate Bill number 183, please.
Thank you. Chair Coyne and members of the Judiciary Committee. My name is Carol O'Donnell. I am chair of Rhode Island Builders Association. I also own a small construction company, CRM Modular Homes, as well as a remodeling company, Emerald Reconstruction. Rhode Island Builders Association represents over 900 members in the industry. I have grave concerns pertaining to 183 and 528. As you're aware, we have a housing shortage. The bills presented will add to this crisis. They are a deterrent to investors and finances. The bills would have a negative effect on new unit construction, vacant units, and rehabs. Homelessness will increase. Now, on a personal note, I own rental units. I've worked days, nights, weekends, keeping the properties clean, safe, modernized, and energy efficient to provide homes to families who reside there. And there are many. In my opinion, both bills, 183 and 528, will devastate not just me, but all multi-unit owners. To expect us to lose our rights in the properties we have worked so very hard for, I find outrageous. We have worked with all of our families through this pandemic, and those families who've worked with us are still residing in their homes. There are some who have taken advantage of our kindness. The bills cannot and should not tie our hands at any time to further incur financial hardships. We have incurred huge expenses, trash removal, everyone's home, sewer and water usage, constant tax increases, water backups, sewer backups from so many people home that are doing things they shouldn't be doing. And that's only to mention a few. We have a few tenants with their extra COVID money that decided to maybe start some substance abuse. We had a drug raid in a 12-unit. We have 11 other tenants that are petrified. So how do I take care of those tenants for one bad apple now, who still reside there, who still owe months of rent? Bill 182 should not force me into mediation, nor declare when the rent should be paid. This is private property. We're providing housing. We take in homeless. We support the source of income. We have Section 8. We have veterans. We have everyone that we open our housing to and provide homes, with utilities included. But we should not have our rights taken away. 528 will create potential renters the ability to take advantage of landlords before becoming a tenant. I shouldn't have my rights taken away. I should know, just as if you're applying for a job, what your background is. We all need to know that. As a minority business owner who has and continues to provide homes for the Rhode Island families in Rhode Island, both as a contractor and a landlord, I'd like to thank you for considering my opinion and the hardship the bills will create for all of us.
Well, thank you. Yes, and thank you for sharing your experiences with the committee. It's important to hear from both sides, so I do appreciate your testimony. Do any committee members have any questions of Ms. O'Donnell? Thank you again for your call tonight.
Thank you. Bye.
Do we have Senator Casada available?
I'm here.
Oh, very good. Senator, we don't have any testimony on S-265 at this time, so we're going to move to your bill S-413, and I inadvertently skipped over 413 for a sponsor's introduction and explanation of an act relating to businesses and professions, real estate brokers, and salespersons.
No, we did that one.
Okay, so it's 421.
421, yes.
Very good. An act relating to property immigration status.
Yes, this is a very short bill, and I'm going to be fast. Thank you, Madam Chair. What it does is to prevent landlord to discriminate for somebody for being undocumented, to prevent them, to ask them, not to require for them to present they are legal in the country. That's what this bill is. It's a very short bill. Anybody can read it, and that's what it is to try to prevent discrimination again. It's so many people in this country, sometimes they have visa, they have working papers, they have so many statutes. It's very hard for people sometimes when you don't know what's immigration, or you're not used, or you're not an immigrant, you're not be able to understand it. Then that's the issue of this. Thank you. I will answer any question we may have. I know we have a long hearing, and I've been listening to all the testimony, and thank you.
You're welcome. Do any committee members have any questions of Senator Casada at this time? Okay, thank you very much. We'll see who's up on the list next for public testimony. Okay, very good. We're going to revert back to S413, which is also Senator Quesada's bill, an act relating to businesses and professions, real estate brokers and salespersons. I believe we have Mr. David Salvatore from the Rhode Island Association of Realtors on the line. Welcome. Mr. Salvatore?
Yes.
You may begin your testimony on S413, please.
Hi, thank you, Madam Chair and members of the committee. My name is David Salvatore. I'm the Government Affairs Director for the Rhode Island Association of Realtors. I will try to exercise some brevity. Thank you for the opportunity to speak on this bill. I want to just take a quick moment and thank Senator Quesada and the co-sponsors of Senate Bill 413 for introducing it on our behalf. So this bill would require all prospective and future Rhode Island real estate licensees to complete a fair housing course prior to obtaining and renewing a license. The bill also requires all licensees, including reciprocal licensees and attorneys and brokers, to complete 24 hours of continuing education every 24 months. This is already a requirement under the rules and regulations of the Department of Business Regulations. However, it was never codified in the Rhode Island general laws, so that's why it's included in the bill before you. Madam Chair, RIAR and our members recognize the significance of the Fair Housing Act, and I'll point to my written testimony for some of the measures that we've taken during the last 3 years to ensure that real estate licensees are accountable for their actions. However, we recognize that there's more work to do, and Senate Bill 413 reconfirms our commitment to upholding fair housing laws, as well as offering equal professional service to all in the search of a home or a piece of property. While it's important to note that fair housing is more than a lot of or a list of do's and don'ts and rights and penalties, we think that requiring licensees to take fair housing courses reinforces an open market that embraces equal opportunity and doesn't shut the door on those who want the same American dream that you and I have experienced. So on behalf of the more than 6,000 Rhode Island realtors, we believe that this is a positive approach to fair housing practices, as we want our members in every real estate licensee throughout the state to aspire to follow the spirit as well as the letter of the law. Madam Chair, I'll conclude by saying that this bill is a work in progress. I have been speaking with the sponsor on some potential changes to strengthen the legislation, and I'm hoping a sub-A will be introduced in the very near future. I'm happy to share with you and the sponsor what those changes could be. But for the time being, it's important for you and the members of the committee to know that RIAR remains committed to addressing the inherent bias that has been part of the real estate industry for too long. Thank you for the opportunity to appear before the committee.
Thank you very much, Mr. Salvatore. Does any of the committee members have any questions at this time? I don't see any, and we look forward to you working together with the sponsor on those changes. Thank you.
Thank you, Chair.
Next, we have Mr. Stephen Brown from the ACLU of Rhode Island. Welcome to the committee, Mr. Brown. You're here to testify on S413 and I believe also S421.
Yes, and one other bill, 561,
yes.
Or 563, I'm sorry.
That's fine.
Thank you very much, Chair and members of the committee. I'm speaking on behalf of the ACLU of Rhode Island in support of three bills. The first one is 413, which you just heard Mr. Salvatore talk about. We also support this legislation for the reasons he mentioned in terms of making sure that fair housing laws are something that realtors understand and enforce to the extent they can. We have submitted written testimony on it, and we do propose an amendment that we hope the sponsor will consider. The way it's worded, it requires the realtors to know about the state's fair housing statute, but there are a number of other anti-discrimination laws relevant to housing that we believe they also ought to be trained on, and so we would urge an amendment to that effect. The second bill, S421, which Senator Quezada just very briefly introduced just a few minutes ago, is something we also support. Banning landlords from inquiring about a tenant or prospective tenant's immigration or citizenship status. Those inquiries, it's clear to us, are really a proxy for discriminating against people, whether it's based on their surname, their ethnicity, their appearance, or other inappropriate characteristics. There's simply no reason whatsoever for a landlord to be asking those questions. We do know, however, I know from talking with agencies that work with immigrant communities, that this is a real problem that families encounter, and so we hope that the committee will look favorably on passing this legislation and preventing landlords from discriminating against tenants on that basis. And then finally, S561, Senator Coleman gave an excellent introduction to it at the very beginning of this hearing. This is the one that would update the state's anti-discrimination laws on the basis of sexual orientation in housing. We think that is really all it's doing. It's updating the law that has become, some of the language is archaic, and so we hope that the legislature and this committee will also look favorably on that bill as well. With that, I'll be glad to answer any questions.
Thank you, Mr. Brown. We appreciate your concise and very organized testimony this evening. Does any of the committee members have any questions of Mr. Brown? We don't see any at this time. And thank you for your testimony.
Thank you.
We don't have any verbal testimony on Bill S523 or 524 at this time, so we now move to S528. And this is an act relating to Property, Residential Landlord, and Tenant Act. Just a moment, please. I believe we have Gregory Wachmulski, Tenant Network of Rhode Island, to testify on Bill S528. Welcome to the committee.
Thank you so much. First, let me say we all really appreciate the service of the chair. Senator Coyne, you're doing a heck of a job tonight. There are an awful lot of callers. There are an awful lot of housing justice bills, and we've been hearing some really great performance opinions on a lot of these matters. I'm here to testify tonight on 183 as well as 528. At Tenant Network of Rhode Island, we get a lot of calls from a lot of renters, a lot of tenants, a lot of landlords, a lot of people wondering, why is it exactly that we need to steal eviction records? And I'm going to let other people speak on that tonight. We also get asked a lot about why is it that the state needs an expanded moratorium when the CDC moratorium may get extended at the end of this month. And I have to tell people because of two reasons. The first one is, pretty clear. The difference between 9 and 20-day evictions is that 20-day are for any reason, 9-day are for non-payment. Right now, we're seeing about 2,700 evictions since coronavirus, and that figure is up to the beginning of February. Out of those, about 30% of them have been for reasons other than non-payment, 20-day evictions. And those, as you may know, aren't covered under the CDC eviction moratorium. So that Band-Aid, even if it does get extended, is missing out on almost 1,000 people so far who would not be covered. That figure is up, actually, over previous years. The average number of non-payment evictions, 20-day evictions, is usually about 50% lower than that in any given year. So even if the CDC moratorium were to get extended, it wouldn't protect all in Rhode Island. And the second reason that I have to tell people that we need a real comprehensive moratorium on foreclosures and evictions in our state is because the CDC doesn't cover landlords. It does not protect small and medium-sized landlords, many of whom being a landlord is not a vocation, it's a situation. Folks from communities of color and black communities who own a home that they rent out to a tenant. They need to be protected from the banks foreclosing on their mortgage during a public health emergency, like we have now and may have in the future, declared by the governor. The bill that is going to become law in the state of Rhode Island, 183, protects all of those landlords. And that's why we have to say to people, we need real protection here in Rhode Island. 2 facts before I go. When you look at the statistics, the whitest places in our state see the lowest number of evictions. And when you look at the numbers in our state, the poorest areas in our state, District 15 in Pawtucket, District 49 in Woonsocket, and District 21 in Warwick, have the highest numbers of evictions filed. Out of those 3 districts, one senator's name is on this bill. And for some of the others in the committee, some of the others who are going to be voting on this when it gets recommended out onto the floor of the Senate for a vote, and for everybody who called in tonight, no matter if you're a landlord, an attorney, or somebody from South Providence trying to speak their truth to power, I just have one thing for you. We see your true colors shine through.
Okay, thank you very much, Mr. Walmusky. We appreciate your testimony. Next is Jerry Brennan, I believe. Whoops. Thank you for your patience. We are just attempting to get the next caller on the line. Thank you. I believe we have Mr. Jerry Brennan on the line to speak on Senate Bill 528. Welcome to the committee, Mr. Brennan.
Thank you very much for having me. Well, let me just introduce myself. I've been a landlord in Rhode Island for over 20 years. I'm an immigrant. I started off with one single family, and over the last 20 years, I've worked it up to a number of different apartments. This bill and some other bills that are coming through would, to say the least, affect my way of operating business. Work with a lot of tenants around the Mount Pleasant area, Silver Lake area, from all different communities, and right now it gives me the chance to work with tenants in a way that works for both of us. Sorry, I'm cut off a little guard with this because I didn't actually realize I was testifying, but well,
Mr. Brennan, You can simply say whether you oppose or support the bill.
I oppose this bill.
Okay.
It would definitely affect my living, and it would also affect the way I work with tenants.
Well, thank you very much for taking time to call. I'm sorry you were off guard, but at least we have your testimony on record, and we do appreciate you calling.
Thank you very much.
Thank you. Next, we have Mr. Manny Aniceto from Rhode Island Coalition of Housing Providers. Welcome to the committee, Mr. Aniceto. You'll be testifying on Senate Bill 528. Well, it looks like we lost him. We're going to try to reach him once again. Welcome to the committee, Mr. Aniceto. I believe you're from the Rhode Island Coalition. Okay, we're having some technical difficulties at the moment, and just stand by, please. Thank you for your patience. Thank you. Next, we have Joshua Nault from Rhode Island Center for Justice. Good evening, Mr. Nault. You're on right now to testify on Senate Bill 528. Welcome to the committee.
Thank you. Thank you very much, Ms. Chairwoman and members of the committee, for allowing me to speak this evening. My name is Joshua Nault, and I am a public interest attorney with the Rhode Island Center for Justice, along with Jordan Mickman and Jen Wood, focused primarily on eviction defense and housing law. I am excited to speak tonight in support of Senate Bill 528 because an eviction on a tenant's rental record is often the most difficult barrier to securing a new rental unit. As anyone knows, evictions can happen for different reasons, but in Rhode Island, the person who is sued for eviction is subject to immediate reputational harm from the time of filing a lawsuit. Not only is this unfair for the tenant, who at that point has not had an opportunity to answer the complaint or challenge the validity of the action, it also undermines the goal of the plaintiff landlord by automatically creating an impediment to the defendant tenant finding new housing. To clarify, if the goal of most evictions is to remove a tenant from the property and the tenant's reputation is harmed as a result of the eviction simply being filed, then the plaintiff landlord necessarily impedes their own expedient recovery of the property by making it harder for the tenant to relocate. This can also contribute to protracted eviction proceedings and an unnecessary and preventable loss of unit marketability. Of course, a landlord has an interest in knowing to whom they're leasing a property, and Senate Bill 528 does not inhibit that interest in any meaningful way. Indeed, the interests which support the kind of judicial transparency that landlords require are primarily interests of health, safety, and financial stability of the tenant. Since financial stability is easily determined through credit checks, income verifications, and landlord references, the primary interests in judicial transparency for landlords become health and safety. Senate Bill 528 permits for those interests to be protected because if the eviction is based on the tenant's risk to others' health and safety, there's little chance that the eviction would be settled or resolved outside of formal litigation. Senate Bill 528 accommodates and protects these interests because eviction actions which end in judgment against a dangerous tenant are automatically unsealed and made available to potential future landlords. Another common occurrence in eviction actions is when the case is settled by agreement between the parties. Importantly, actions that end in settlement are not technical evictions, but are amicable resolutions to the lawsuit entered into by the parties. Our district courts in Rhode Island often encourage settlements between parties, and as such, a significant amount of eviction actions brought in district court end in amicably resolved agreements that result in something other than actual eviction. Nonetheless, without Senate Bill 528, those resolved actions remain viewable to potential landlords and are often made available to landlords through private service providers who often fail to provide the context behind a person's eviction record, such as an amicable resolution to the matter that ended in something other than eviction being executed on the property. Senate Bill 528 would preclude such misreporting by private service providers because, according to the bill, settled cases are sealed unless and until the parties fail to abide by the terms of the settlement. Even more, if in such a circumstance occurs where there is noncompliance, the record can be unsealed and made public for any future landlord to view. For all of these reasons, I am in favor of this bill, and I strongly encourage and respectfully request this body to pass this bill so that tenants' reputations can be more protected than our current system allows. And if I may also take a moment to voice my support for Bill 183 as well, which I think is integral to this moment in responding to the COVID-19 pandemic.
Yes,
and thank you very much for allowing me to speak.
Yes, Mr. Nault, thank you so much. We have a long agenda, but you got a lot in there in a short amount of time, so we appreciate that. Do any committee members have any questions of Mr. Nault? Okay, thank you so much for your testimony. We appreciate you joining us this evening.
Thank you very much. Have a good evening.
Okay, next that finishes the testimony on S528, and we're going to move to Senate Bill 561, an act relating to property, Rhode Island Fair Housing Practices Act. Do we have Alex West? Very good. I believe we have Alex West from South Coast Fair Housing on the line. Welcome, Mr. West.
Welcome. Thank you, Madam Chair. Good evening, everyone. My name is Alex West. I work at South Coast Fair Housing. We're a nonprofit fair housing organization with offices in Pawtucket as well as New Bedford, Massachusetts. We cover all of Rhode Island. we'd like to thank Senator Coleman and other supporters for bringing Senate Bill number 561 forward. South Coast Fair Housing strongly supports this bill. We have experience enforcing comparable state law in Massachusetts, which has been in place since 1971. In our work, we see how these protections help tenants and increase housing opportunity. I'd like to briefly highlight a research report that South Coast released recently, completed with help from students at Brown. The report is called "It's About the Voucher: Source of Income Discrimination in Rhode Island," and I've submitted this report electronically as well for you to peruse in your leisure. The report presents our research into exactly how much discrimination Rhode Island voucher recipients encounter when they go out and try to find an affordable apartment. Anecdotally, we know that these tenants experience very high rejection rates, but we wanted to gather additional Rhode Island-specific data. So our research had two phases. In the first, we monitored online rental listings on websites like Craigslist or apartments.com. And secondly, we conducted a phone audit of housing providers who had recently advertised units. Ultimately, we found that the combination of cost and discrimination exclude voucher holders from 93% of local housing opportunities. Tenants with a voucher should have been able to afford more than a third of the units, but they were denied the chance to even submit an application in all but 7% of instances, solely because of their source of income. You can read more about our findings in the full report, but the takeaway that I'd like to leave the committee with is that income-based discrimination is a widespread problem in Rhode Island. A quick search of advertisements, even today, on popular websites like Zillow, Craigslist, Facebook Marketplace, and Apartments.com yield numerous current examples of housing listings that explicitly reject voucher holders throughout the state of Rhode Island. This issue affects the entire state. The proposed legislation does not restrict landlords' existing ability to screen tenants based on other lawful factors. So landlords may still confirm the source and amount of a tenant's income in order to ensure that he or she can fully make their monthly payment obligations. Many tenants would benefit from the protections in this bill because many still experience discrimination as an obstacle to safe and decent housing. I'll be brief and leave it at that, and I'm happy to answer any questions about South Coast research or our work in Massachusetts. Thank you.
Thank you very much, Mr. West. Do any committee members have any questions? We don't have any questions at this time, and thank you for your testimony.
Thank you.
I believe we have Lori Marie Piscota from the Mental Health Association of Rhode Island.
Hi.
Good evening and welcome to the committee.
Good evening, Madam Chair and members of the committee. Thank you so much for this opportunity, and thank you, Senator Coleman, for introducing this important legislation. My name is Lori Marie Piscota, and I'm the Executive Director of the Mental Health Association of Rhode Island, and we support Senate Bill 561. You may be wondering why Mental Health Advocacy Organization is testifying tonight on a housing bill, and that's because stable, safe housing is the foundation of good mental health. Housing is recovery, and housing is the foundation of all the good things in our lives. You might associate housing vouchers with people of low income, and that is certainly true, but I really want to make the point that many people with disabilities who live on SSI or SSDI benefits also receive housing vouchers. So I'm here talking about people with intellectual developmental disabilities, physical disabilities, and people with serious persistent mental illness. I'm sure you can imagine how nearly impossible it must be to find affordable housing when living on a fixed income, like Social Security disability benefits. Housing vouchers are critically important to people with disabilities. I lived in Massachusetts for 10 years, where I served as a case manager for adults living with HIV/AIDS. And in Massachusetts, we already have a law prohibiting landlords from discriminating against lawful sources of income, like Section 8. And without this law, I can tell you that case managers would never have housed any of our HIV-positive clients, because most of our clients lived on disability benefits and received housing vouchers. I've heard landlords express concerns that if they can't discriminate against people with housing vouchers, then they might get stuck with a terrible tenant without any power to evict them. But I don't believe that's what this bill does. I think that's a false choice in terms of this particular piece of legislation. This legislation doesn't force us to choose between stopping discrimination or forcing landlords to keep bad tenants. I think we can protect both parties. There's nothing in this legislation that prevents a landlord from doing a credit check or a reference check or inquiring about a person's income. I can't speak to other facets of Rhode Island's landlord-tenant law, but this particular piece of legislation I don't think adds to that problem. It should be noted that bad tenants can and do lose their housing vouchers when they commit drug-related criminal activity, when they don't pay their rent and are facing eviction proceedings, and when they don't keep the utilities on in their units. So there's a lot of incentive to be a good tenant when you have a housing voucher, because if you lose your housing voucher, you may be eligible to apply for a housing voucher again, but you go at the very, very bottom of the list, and right now Section 8 has a 10-year waiting list. So housing vouchers might be indicative of a person who's a good bet for a landlord. This legislation is very important to people who live with disabilities. It doesn't cost the state anything to pass this legislation. I feel it's literally the very least that we can do to make a positive impact on the lives of people with disabilities. And it might even save money in the long run if we have fewer people doubling up with relatives living on the streets, cycling in and out of emergency room departments, hospitals, prisons, and homeless shelters. Passing this legislation sends the message that Rhode Island does not tolerate discrimination against people with disabilities. I respectfully urge this committee to vote in favor of it. I thank you for your time, and I'm happy to answer any questions.
Ms. Pashota, we appreciate your testimony. Do any committee members have any questions of this witness? Thank you for joining us tonight.
Thank you. Good evening.
Good evening. Next up, we have Callie Babbitt Spears from SOAR, Sisters Overcoming Abusive Relationships, and also representing Rhode Island Coalition Against Domestic Violence. Good evening, Ms. Spears.
Hi, good evening.
Good evening. You may begin your testimony on Senate Bill 561.
Thank you so much for your support, everybody here tonight. Good evening. My name is Callie Babbitt Spears, and I am a community activist, a mother of 6, and a survivor of domestic violence, and a member of SOAR, Sisters Overcoming Abusive Relationships. I am here today urging you all to support Senate Bill number 561, and this is why. When I was 20, I moved here to Rhode Island and met my now ex-husband. We moved into a house together after we had our first child. In that house is where the abuse began. Throughout the years that followed, our family grew and the abuse escalated. He threatened and assaulted me many times. While I wanted to leave, I feared becoming homeless and having to live in a vehicle with my children. I had no support. We were dependent on his income. I was finally able to leave and seek safety at a local domestic violence shelter. Because I was low income and most of my income was public assistance, my choices on where to live were really limited. I accepted an apartment with enough rooms for me and my children, but that was not safe. I knew my ex-husband would find me in that apartment complex. It was a small town, and this was the only low-income community there. Because of my source of income, I was forced to make a decision between safety and a roof over me and my children's heads. I applied for Section 8 shortly after moving in, and it took 8 years, actually. It took 8 years to receive that voucher. Even with the voucher, many of the options were out of my price range. After a very frustrating search, I finally found an apartment I could afford. But unfortunately, I was rejected by the landlord for having a voucher. Another landlord who knew I had a voucher told me he preferred to rent to college students. Having a voucher became more of a barrier, and I felt so nervous telling landlords I had a voucher in fear of rejection, even in the last minutes of me being able to qualify. Other people also who had Section 8 told me I shouldn't tell landlords about the voucher or they wouldn't rent to me. Ending discrimination based on source of income would have protected me from being denied a home just because I was receiving public assistance. At the end, I lost that voucher because I could not find someone that would rent to me and my family. I left an abusive relationship to then be controlled and affected by the lack of housing options available to keep me and my children safe. While safety is not included in the cost of rent, having a choice of where to live is the security that many families fleeing violence need. We must end the source of income discrimination. Thank you very much.
And
for your.
Go ahead. I was just going to
say,
I really,
much for your.
Yeah, I do appreciate your sharing your personal experiences.
Thank you.
Yes, very much, and for taking time to share those with our committee members.
Okay.
Thank
you for your consideration and importance of this legislation.
Of course. Do any committee members have any questions? Thank you again, Ms. Spears. Next up, we have Mr. Robert Marshall from the Rhode Island Developmental Disabilities Council. Welcome to the committee, Mr. Marshall. Thank you for joining us.
Thank you.
Yes,
Thank you, Chair Coyne and members of the Judiciary Committee. I'll be brief. Lori Marie just said pretty much everything I wanted to say and then some. We've been working very closely with the Mental Health Association on this particular issue. For people with developmental disabilities, they're almost always going to be relying on a Section 8 once they try to realize their dream of living independently. And if that's the case, then if we're going to continue to allow landlords to run ads that say no Section 8s, we might as well just tell them to run ads that say people with disabilities need not apply. The Senate has seen this and passed this bill in the past. We've had trouble in the House, but we've gotten it through the House this year. We hope the Senate will stand behind it and pass it again so that people with disabilities, with intellectual disabilities, people with physical disabilities, and people with mental health, persistent mental health issues can, find housing, be good tenants, and realize their dreams. Thank you again for your time, and I'll be happy to answer any questions.
Well, first of all, I want to say thank you for your committed service and your advocacy for the developmental disabled in our communities. Do any committee members have any questions of Mr. Marshall? We don't have any at this time, and thank you, sir, for joining us this evening.
Thank you. Have a good night.
Next is Ms. Catherine Gradowski. Good evening, Ms. Gradowski. You may begin your testimony on Senate Bill 561.
Hi, Chairwoman and members of the committee. Thank you for taking the time to hear my testimony. I'm a small property owner and a Section 8 landlord, and I'm asking you to support Bills 561, 528, and 183, as well as the bills regarding sexual orientation and immigration status. Regarding Bill 561, this bill will help expand the reach and impact of one of Rhode Island's most valuable housing programs, the Rhode Island Housing Section 8 Voucher Program. Obviously, this bill isn't exclusive to vouchers. It covers unemployment, SSI, veterans benefits. But since that's the program that we know about, that's the one I'm going to testify on. As a landlord, I can testify to the value of this program from an owner's perspective. Participating in this program has helped us find and maintain reliable, high-quality tenants. It has provided a stable, reliable source of income during the pandemic. Rhode Island Housing has been a responsive partner, and they've actively helped us to keep our building in compliance. And I just want to stress that we've participated in this program for a number of years now, and we have not been adversely affected in any way by our participation in this program. We haven't found compliance to be invasive or onerous. On the contrary, it allows us to find high-quality tenants, maintain our property, and increase our investment in the neighborhood. It's a travesty that tenants wait years for a voucher only to find that they can't get a landlord to rent them. As South Coast Housing testified earlier, over 90% of voucher holders have been barred from over 90% of apartments that they can afford due to their source of income. And as you know, as others have said or will say or have testified, this legislation doesn't force us as landlords to lower our rents. It doesn't prevent us from screening tenants. It prevents us from refusing a tenant based on a lawful source of income. We should not, in our legislation, be permitting discriminatory practices in the interest of protecting marginal profit margins that aren't actually at threat from this bill. This legislation has come up many times before. It's been discussed and considered exhaustively, and I encourage you to pass it. If I have extra time, I'd like to speak briefly in support of 183 and 528.
Yes, briefly, please.
Thank you. Regarding 528, as a landlord, we are more than capable of doing research to find out whether a tenant is creditworthy without inquiring into their eviction history. Notice of a record doesn't tell you anything that you can't learn from a credit check and a reference check, but it can do irreparable harm to tenants by creating an additional barrier to entry, like the presence of a Section 8 voucher. It can be a backdoor to discriminatory practices, including illegal discrimination that this committee should commit to addressing. And the same is true about a tenant's immigration status. It's simply not relevant to whether they can pay the rent or whether they keep the apartment in good shape. And lastly, regarding 183, it's important to keep in mind that the eviction moratorium doesn't provide money to tenants to help them pay the rent. What it does is it creates a critical window for rental assistance programs to mobilize to support both tenants and landlords. To date in Rhode Island, through COVID-19, these programs have paid out $7,200,000 directly to landlords, and yet eviction filings continue to pile up. In Providence County, we're in the middle of a global pandemic. Obviously, we're averaging 10 evictions a day. The fact that we're not first in America in evictions shouldn't prevent us from addressing that problem. I support all of these bills in their entirety. I think it's important that there are a lot of landlords out there who believe that these are important bills and that this is important legislation to pass. Thank you for taking the time to hear my testimony. I really appreciate everyone on the committee, and thank you for considering these bills.
Of course, and thank you so much for your patience this evening. We have a long list of witnesses, so thank you for your call. Any committee member has any questions of Ms. Gradowski? All set. Thank you so much. Next up, I believe we have Ms. Hannah Stern of the ACLU of Rhode Island. Welcome to the committee, Ms. Stern.
Thank you, Madam Chair and members of the committee, for your time this evening. My name is Hannah Stern. I'm testifying on behalf of the ACLU of Rhode Island in very strong support of this legislation. The advocates tonight have well highlighted the many merits of this bill, so I'll be very brief, but I do just want to emphasize the protection that this legislation would ensure for members of lower income or marginalized communities in their search for stable and healthy and affordable housing. There really should be no reason that an individual should find themselves at a disadvantage in the housing market simply due to where their rental money is coming from. And there really should also be no ability for a landlord to deny a tenant based on the source of their income. So this legislation would appropriately make sure that tenants are not vulnerable to these situations, and we urge passage of this important bill. So thank you very much for your time. I'd be happy to take any questions.
Thank you very much, Ms. Stern. Any questions for the witness committee members? No questions at this time. Thank you, Ms. Stern.
Thank you.
Next up, we have Elizabeth Burke-Bryant from Rhode Island Kids Count.
Good evening. Thank you, Madam Chair and members of the committee. My name is Elizabeth Burke-Bryant, Executive Director of Rhode Island Kids Count, and I'm here to provide our very strong support on Senate Bill 561. We'd like to thank Senators Coleman, Quesada, Chacon, Goodwin, Mack, Acosta, Oyer, and Murray for sponsoring this bill, and to Senator Coleman for introducing it. We are strongly in support of this bill because we know how difficult it is for families to find affordable housing. In 2019, 279 families with 603 children from across the state stayed at emergency homeless shelters, domestic violence shelters, and transitional housing programs. And we know that these numbers have only grown since the pandemic hit and many families have lost their jobs and homes. I know that you know that it is a long wait to get a housing voucher, formerly called the Section 8 voucher. Sometimes families wait 5 to 8 years to receive a housing choice voucher. And once they get them, it is just wrong that they can't use them because so many landlords don't take Section 8 or housing choice vouchers. This bill would rectify that problem, and it has been a long-standing problem with families being turned away from dozens of units before they find a landlord who will rent to them with a voucher. And some families simply give up. This is just a really, really important bill for Rhode Islanders, including children and families. We urge you to support this bill. I also want to say that we submitted written testimony in support of Senator Mack's Bill 528 and Senator Oyer's Bill 183. Thank you for your attention this evening.
And thank you so much for joining us this evening. And you're a regular before our committee, so I really do appreciate all that you do for Rhode Island kids. And thank you again for your testimony this evening. Does anybody have any questions for Elizabeth Burke-Bryant? We don't have any questions at this time. Thank you.
And thank you so much. I appreciate the opportunity. Good night.
Sure thing. Just to let the committee members know, we're actually nearing the finish line here. We have perhaps 2 or 3 more witnesses before we conclude this evening's testimony. I believe we have Janice Flora Arsenal on the line. Good evening, Janice Flora Arsenal. You're here to testify on Senate 561.
Yes, hi. The reason why I wanted to testify is because I have a Section 8 voucher, and a Section 8 voucher does really help me to survive. And I'm low income, and I'm also disabled. I get SSDI, and if I didn't have the Section 8 voucher, I wouldn't be able to live. It would be too hard for me to afford to live with how high rents are, and landlords should not be able to discriminate against people that have Section 8 vouchers. And, they should be able to rent to people even if they have a Section 8 voucher or even if they have a disability. And last week I ran into a problem with my own landlord where I called her because of a heating issue, and she got mad. She didn't believe me it wasn't working, and then she even said, that she didn't believe me that it wasn't working. She said she wanted me out, and she said, and I'm never renting to another gateway client again. And I felt that was discriminatory. Now, I think so far as that issue has been resolved, but even by her saying another gateway client, that was kind of discriminatory, and then she would never want to rent to another gateway person again. I don't think landlords should be able to do that and say, never another mental health client again. That was kind of discriminatory, I thought. But at least I think so far that now she realizes that there really was a heating problem in the whole house, and she knows that, but she shouldn't be able to think that, because I was the one that called her, and not any of the other tenants, that, just because it was me and not anyone else, to think that, it was just a her problem, not the housing problem. But it was a heating problem. They shouldn't be able to do that or have a vendetta against the tenant just because they have a voucher or they know the person has a mental health condition. And and I didn't do anything wrong. All I did was tell her that there was no heat.
Well, it's really important to hear experiences from Rhode Islanders out there in the public, and it's very helpful when we go to assess the legislation that has been filed and is in committee to be heard. So I do appreciate the time that you've taken today to call in and share your experience. Do any committee members have any questions of the witness? Thank you very much for your call.
All right,
Have a good night. Now we're going to move on to Senate Bill 563, an act relating to property, Rhode Island Fair Housing Practices Act. We have no testimony for Senate Bill 501 or 504, so this will be the last bill that we hear testimony on. I believe the first witness up is David Savitsky, Dr. David Savitsky. Good evening, Doctor. Welcome to the committee.
Hello. Hello. I assume you guys, I'm speaking to the committee now.
Yes, and you are speaking on Senate Bill number 563, an act relating to property, Rhode Island Fair Housing Practices Act.
Yes.
Thank you.
So, hello, Senators Coleman, Mack, Savani, Cano, Valverde, DiMario, and Golden. I wrote this out and submitted it in writing, so you have it as well. But I made it very short. I'm a resident of Providence, a constituent of Senator Golden. I work in Rhode Island at a large mental health center, Gateway Healthcare. It's a lifespan partner, and where I'm a child psychiatrist and associate medical director. So this testimony, I'm not representing my agency, but I would like to offer the illumination of the value that this bill would provide to my patients. When my patients have to move, it is an ordeal at best. And if they knew that financial ability to pay the rent, ability to live peacefully with their neighbors would determine whether a landlord would rent to them, it would be tough, but it would be fair. However, the exemption in this law that allows a landlord to discriminate purely on the basis of the expression of gender identity or sexual orientation is manifestly unfair. It's resulted in patients who remain in unsafe situations because they're unable to find a safe place that will rent to them. It has pressured patients to hide their identities and orientations, which results in psychological damage, worsening of depression, and raises anxiety. The amendment to the fair housing laws would simply delete that opportunity to express prejudice in a public arena. It makes our state a more fair and welcoming home for all, and I wholeheartedly support this bill.
Thank you, sir, for your testimony. Do any committee members have any questions of this witness? Thank you very much. Next, we'll go on to Mr. Ethan Huckle, TGI Network of Rhode Island. I believe we have Mr. Huckle on the line. Welcome to the committee, and you're testifying on Senate Bill 563.
Yes. Thank you, Madam Chair and members of the committee, for your time tonight. My name is Ethan Huckle. I am testifying in support of Bill 563. I serve as the board president of TGI Network of Rhode Island, which is a nonprofit serving the transgender community with peer support and advocacy. And this legislation is an important step toward improving the lives of community members by protecting their right to fair housing. Housing is honestly the number one issue that community members bring to us, the lack of available and safe housing. I know you know that transgender people face discrimination in all arenas of life, so I won't go into all of those statistics. But housing discrimination remains a major impediment to our physical, mental health, and safety. So many community members can afford housing, but they can't find people who will rent to them. They report that they respond to available listings only to be denied upon arrival. Or they have housing and they're subjected to harassment and abuse because of their gender expression. It's important to note that transgender people are much less likely to have a support network to rely on, and the lack of housing leads to higher rates of anxiety and depression and other unsafe housing choices. It's a problem that really compounds. So I urge you to consider first how your life would be affected if you couldn't rely on your housing to be safe or secure, regardless of your ability to pay rent. And we at TGI Network urge you to support this bill and vote it out of committee. Thank you.
Thank you very much. Does anyone have any questions of Mr. Huckle? Okay, thank you. I would like to let the committee know that we have 5 more witnesses, and they're on S-183. So we'll step back to 183 and see if we can contact these witnesses so we can finish up. Okay, I believe we have Molly Scavuzzo-Dugan on the line to speak on Senate Bill 183. Welcome to the committee, Ms. Scavuzzo-Dugan. You're speaking on S-183.
Hi, thank you. I appreciate you taking the time to circle back around to me, and I do want to keep this brief, just to give others chances to be able to talk. So I primarily do want to testify in support of 183, and while I did try to see if it was possible for me to testify on behalf of my employer, I never got word back from them about that. But I want to, just share a little bit of my experiences working through the coordinated entry system in Rhode Island. That system used to, be run by my employer, but now is with the Rhode Island Coalition for the Homeless. And while I don't have, a well put together testimony, and I'm very impressed with what I've heard tonight regarding, the numbers and statistics of people who have lost their housing because of this pandemic and because of predatory practices by their landlords to get around the eviction moratorium. I can tell you all from anecdotal experience how incredibly heartbreaking and just gut-wrenching it is to listen to family after family and person after person on the phone crying and sobbing with me to try and see if there's any way that I can save them from losing their housing, being outside, and in some cases experiencing the trauma all over again of having to sleep outside. I can tell you right now that it is a well-known fact amongst all of us that shelter space in Rhode Island is extremely limited, that waiting lists are often weeks, if sometimes almost a month long in certain places. And some people are also, at a point where they've experienced homelessness for so long that they've ended up burning bridges with a lot of these shelters. So when they lose their opportunity to be able to, get protected from eviction, they often have nowhere else to go. Sorry, it's rambling, but I just want to say that I think it's vitally important that the committee pass 183. I think you're going to be saving a lot of lives. That's my piece.
Thank you very much, Molly. I appreciate your testimony. Does anybody have any questions for Molly? Thank you so much for your testimony.
I appreciate you taking the time to hear me out. Thank you.
Of course.
Have a good night.
You too. Next up, we have Deborah Levy from Childhood Lead Action Project. Welcome to the committee, Ms. Levy.
Hi, thank you. Thank you so much, Chair Coyne, and to the members of the committee, and thank you for coming back to this important bill to hear our testimony. I really appreciate it. My name is Deborah Levy. I'm a renter in Providence, and I'm a community organizer at the Childhood Lead Action Project. We're a local community organization dedicated to eliminating childhood lead poisoning through parent support, community education, and grassroots advocacy since the 90s. So I'm here to testify today in support of Senate Bill 183 to institute an eviction and foreclosure moratorium. I also want to voice my support for Bills 528 and 561. I think they all really go hand in hand, so I appreciate you hearing my testimony on all three. I want to agree with what the other supporters of these bills have said and also share the reasons that I'm supporting them. From a professional standpoint, the work that I do in the fight for lead poisoning prevention is part of a broader fight for safe, healthy, and secure housing for all, and linked to the issue of evictions. During the pandemic, lead poisoning has not gone away, and in fact, screening rates are down and poisoning numbers are likely up. But it's really difficult to worry about chipping paint or other lead hazards when you have to worry about keeping a roof over your head. We've heard from many tenants that their landlords would rather move to evict or terminate their tenancy rather than deal with a complaint about lead hazards in their unit. So lead poisoning of young kids can often lead directly to threat of eviction. In the past year, I've also worked on tenants' rights issues more broadly, including one-on-one work with tenants being threatened with eviction. You've heard a lot of their stories tonight. I've seen time and time again that the federal eviction moratorium and the assistance programs we've had in this state are just not enough to keep people housed. The CDC moratorium only covers evictions for non-payment and is not proactive. It involves people having access to the internet, having access to a printer, knowing the steps that they have to take to go out of their way to make sure that they're protected. This bill would address the equity issues with that moratorium and institute proactive protection for Rhode Island's most vulnerable renters. I also know that this is an issue of justice. We know that the burden of eviction falls most heavily on Black people and other people of color, and we know that the wave of evictions that we're seeing in this state is a sign and symptom of systemic racism. This is not just a professional issue for me, it's a personal issue. Like I said, I'm a renter in Providence, so are most of my friends and loved ones in this state. The stories that I've heard from them and from people I've worked with in the last year have been heartbreaking, like some of the ones you've heard tonight. I'm here because I know how much difference this bill is going to make for the people I know, for the people I've tried to help, for the people that I've had to tell that no help is available in the last year. I'm here for them. And I'm here because I know this is what our community needs. Evictions are cruel always, but especially right now. We've been asking for a comprehensive eviction moratorium in this state for almost a year. And honestly, I'm ashamed that it hasn't happened sooner, but it's not too late for this to happen. This bill won't forgive anyone's rent debt. It won't give a home back to people who've already been evicted. But it will give renters and homeowners more time to get back on their feet. And hand in hand with the other bills will let them not end up with an eviction on their record and not be discriminated against for their source of income. So it will help to guarantee people a basic human right in the middle of a global pandemic. So I really implore you to really listen to the stories that you've heard from tenants this evening and to see that voting to pass 183, 528, and 561 to protect Rhode Islanders from eviction, from the stigma it carries, from housing discrimination is really the only ethical choice. Thank you.
Thank you very much, Ms. Levy. Any committee members have any questions? Thank you again for your testimony this evening. We appreciate it.
Thank you.
I believe next up is Kenya Fullen from People's Social Services. Welcome to the committee. You may begin your testimony on Senate Bill 183.
Is this agreeing with the bill?
Yes, you can just testify whether or not, whether you support or oppose the bill.
So I support the bill of not evicting tenants who don't have the means to pay now due to the COVID.
Okay, well, thank you very much. Is there anything else that you would like to add?
That's it. And I don't think landlords should just go to their tenants' houses and just put the stuff out on the streets illegal. That's been going on.
Well, I appreciate you calling in, and I appreciate your testimony.
All right. Thank you, and have a good night.
Yes, you too. Thank you.
All right. Bye-bye.
And I believe that concludes our list of witnesses for testimony this evening. I do want to give a shout out to the public. We put a 3-minute time limit on, and we try to hold to that, and it gives everybody an opportunity to say their piece and be heard. So thank you to the public for your cooperation this evening. I believe that concludes all of our testimony. And with that, I want to also thank the committee members for your attention tonight. It was a long night. And if I could please have a motion to adjourn in a second. Senator Raptakis makes that motion.
Second.
And Senator Casada and Senator Rogers and Senator Archambault seconds that. And we are adjourned. Thank you.
Thank you. Good night.
Good night.